Yes,
May,
please.
may I please, your lordship? Lordship, with due consent from the other side, my lord, I beg to mention item number 31, my lord.
31.
Lordship.
What do you want, gentlemen?
My lord, I want 2 weeks time, my lord, to file improvement petition in this connection. my lord.
Then counsel for the petitioner, the appellant, pays for and granted, and is granted 2 weeks time to move and implement application.
Lordship.
List up to 2 weeks.
Obliged.
My lord, item 34 of today's list, my lord, hearing item, may kindly accommodated within the course of day. Matter was remanded by Honorable Supreme Court on 11th February 2019. It is a pension matter with a request to expedite the hearing within 6 months, still pending. It may kindly be accommodated
You
within.
want the hearing to be done today?
Yes,
All right, come when the matter is called out.
My lord, I beg to mention for listing of the case in hearing, my lord, hearing column. And next week, my lord,
What is the matter about, sir?
my lord, this is matter of the promotion, my lord. The juniors are given promotion and my lord on reservation, but there is application of reservation policy is wrong.
You
That is-
move an application for early hearing, we'll pass appropriate order thereupon. You
My
can't get a matter listed simply by mentioning in the hearing category.
Yes, my
Move
lord.
an application.
Yes.
Okay.
Oh, Lord.
May please, your lordship.
An application. Yes,
I beg to mention item number 23 of today's list. Okay.
yes, please.
With concern of respondent side, lordship. So kindly matter may be fixed after 3 weeks, lordship.
Yes, great. You are for the respondent side,
No, appellant side.
final counsel for the appellant. List up 3 weeks.
Obliged.
Matter number 1 of daily list for motion.
May it please your lordship. Lordship, may kindly pass over the matter for the time being, lordship. My senior is on his way, lordship.
In this matter, my lords, we'll be filing our reply today. I have served advance copy yesterday to my learned friend.
Oh.
Matter may be taken up after the holy break. my lord.
Very well, because on the last date also you were given time
Yes,
for this very purpose.
yes, my lord. I've already served the service copy on him. my lord,
You are
today.
Mr. Ganguly.
Yes,
Mr. A. Ganguly, and counsel for the respondent, bank, submits that he would be filing the counter affidavit during the course of the day.
lordship.
The restrict tag the same with the file and re-notify the matter after in the week commencing from 13th March.
Deeply.
Matter number 2.
Lordship, I beg to pray that one mistake has been done, one handing the service copy to the opposite side. A wrong read has been given to them.
Immaterial, sir. The counter affidavit is already there.
I
Yeah.
have filed my counter affidavit on the basis of the writ petition that has been served upon me.
So you don't bother. He is having the correct copy. Don't worry.
I'm having the kind of, may I pray to my lordship to allow me to serve them the actual one actually.
He has already filed a counter affidavit on the basis of your writ petition. Is it right, Mr. Counsel?
Yes, Lordship.
He is not asking for the correct copy. Why you are worried?
Okay.
He
My lordship.
has acquired the correct copy from his own sources.
No.
Then
No, I have filed the affidavit in opposition on the basis of the copy that has been served upon by me.
so he says that the correct writ petition has not.
Actually, Lordship, as per information given by him, there was 2 writ petition.
Okay, so he has given you other matter.
One writ petition was of 2022, which is already been disposed of, and that copy has been served upon me.
Again, so you have filed affidavit in reference to that writ petition.
With that writ, the copy that was served upon me.
Okay,
And now yesterday he has told me that the writ petition that has been filed,
because what we see from your affidavit is that it is your pertinent case, then even the order sheets reflect that the amount has not been paid.
Lordship, the actual amount has been paid actually. The time is the matter. The amount has
Okay,
been
very
paid.
well. Counsel for the petitioner submits that he has inadvertently supplied wrong paper book to learned counsel. Wrong set of pleadings to learned counsel for the respondents. The error be rectified. The respondents counsel may file affidavit, counter affidavit to the appropriate writ petition by next 2 weeks. Let's thereafter.
Obliged.
after 2 weeks.
Item number 39 of supplementary list.
Simple. Request, my lord, that item number 1 I am for the petition actually. That should be not listed on 13 because I will go out of session.
What day do you want, sir?
15th,
15th laga.
Item number 39 of supplementary list for motion.
May I please, your lordship? Lordship, kindly pass over the matter for time being.
Asking for an idiot. Produce.
The other day, brother, we were talking, the previous court solutions are required to be listed report division met.
Yeah.
And way it has gone through.
This is the.
Okay. Synopsis. You want to pass over?
Time being.
We'll have to put the other side on notice. नहीं, ठीक है ना। We'll have to put the other side on notice. This is a case of detention of minor girl. So we'll issue notice to the state. Ask them to respond. Issue notice. You are appealing for all respondents. There must be some private respondents also. Mr. So and so appears. क्या नाम है पता नहीं।
Mr. Upadhyay.
Upadhyay appears for the respondents numbers 1 to 7. Thus, notice be served. The steps be taken to serve notices upon the respondents numbers 8 to 11. Thus, the service is permitted. Shri Upadhyay shall instruct the police officer concerned to trace out and present the corpus musammat. The first alphabet may be written so and so in this court on or before the next date of hearing. Being the minor daughter of the petitioner, on or before the next date of hearing. List on 15th March.
May I please?
We had provided you a copy of judgment of Rajasthan High Court on the last date. In a similar matter. Revised case. And we had requested you to get the matter re-examined in light of that judgment and the subsequent circulars issued by the state of Rajasthan.
But here, so far as the present case is concerned, like in the Rajasthan High Court's case, here it has been already placed before the anomaly committee.
It has been?
Yes.
Okay. So you take a decision thereupon.
No, their decision is there, my lord, the rule has been amended already. Challenging their
what
amendment,
happened
but
here?
they have come.
If I may just give a background, my lord. 6 CPC, we are with the 7 CPC now, my lord, issues with the 7 CPC. 6 CPC, there were certain pay scales provided for ME school
Have you
teachers.
gone through this, sir?
Yes, sir. Yes, my lord. If
The
this
subsequent memorandums also. Rajasthan.
Rajasthan memorandum with regard to, my lord, the ACPs, how it will be done. My
Yes.
lord, if the government takes an exercise in this direction, hears us, we'll have no grievance. But they will not do that. My lord, we'll see what they have done. The 7 CPC, my lord, my lord may come to page straight away to my lord, this page, that will clear the issue. Page 23 of the petition.
Yes. Page
23, my lord. My lord has got it. Page 23, my lord.
yes.
Annexure 1. Now, this is the recommendation of the 7 CPC. My lord, on the left-hand side, my lord would find the recommendation of the 6 CPC.
My lord would say Assam Lower School Teaching and Inspection MEMB Senior Basic School. Headmaster MEMB Senior Basic School, the pay was 5,200, 20,200 and 3,300. Now graduate teacher therein was given 2,700 as my lord the grade pay. Now junior teacher, my lord, means an undergraduate teacher was given 2,500. Now my lord comes down with regard to LP schools. Headmaster was given 2,700. A graduate teacher therein was given 2,700 and an undergraduate teacher was given 2,500. Now this is the position that is existing from 1/1/2006. Now in 1/1/2016 under the 7th pay commission, the right hand side, 14,000, 49,000, 8,700 for headmaster. Graduate teacher, same PB, 8,700 in ME school, and undergraduate 6,200. Now my lord would see just below LP, headmaster 8,700, graduate teacher 8,700, undergraduate teacher 6,200. Government accepted this, my lord. Government accepted this, money was released to us. So from 1/1/2006, there is no difference between ME and LP. Now, all of a sudden, the government on their own places the matter before the anomaly committee. We are not involved, my lord. Now, the anomaly committee, my lord, would see the recommendation at page 28, my lord. 28, my lord, will have it at page 25, my lord. Sorry.
Yes.
Clause 9. Education Department. Now, my lord, I'll have the bottom last part, my lord. MEMV Senior Basic School UP
Yes,
School.
yes, yes. No, no, you are on page 26.
25 minutes. 25.
25. Yes.
My lord will have the last part. MEMV Senior Basic School UP School. This has been retained at 8,700. Now, my lord will just come to the next page. The undergraduate teachers who were given 6,200 were raised to 6,800. Now, my lord, I'll trouble my lordship with page 25 again, my lord. The top portion, LP, ME, LP Junior Basic Pre-Primary School. My lord would see the trained graduate teachers have been reduced to 7,400. Whereas the untrained graduate teacher,
They've been retained at 680.
no, it was 6,220.
62, they have been upgraded.
Upgraded to 6,880. This is my grievance, my lord. And this was done without any hearing. And the minutes,
So
my
the
lord, would,
anomaly committee has, as a matter of fact, brought in another anomaly,
and
which we are required to rectify.
lordship. and the my lord, the reasoning
Yes.
is available in the affidavit that has been filed by the government, my lord.
Affidavit in opposition.
Opposition filed by the government.
Yes, please.
Internal page 9 thereof, my lord.
Yes.
My lord, before that, a fact, my lord, I'll bring on record. In ME schools, it's undergraduate qualification, but there is a post of science graduate teacher. LP school also undergraduate, my lord. Now, my lord, will read that page 9. This is the pay commission's recommendation, 1.6 down below, my lord. The commission recommends that normal school and basic training centers should be amalgamated and teachers instructed be classified in two categories with graduate qualification and with undergraduate qualification. The teachers with graduate qualification be paid rupees 3,300 and the teachers with undergraduate qualification, trained or untrained, be paid 2,500. Principles of this amalgamated institution should be given. So and so, it further recommended that pre-primary teaching centers in so and so be merged into one common intention. B, the commission recommends that in each LP school, one post of trained graduate teacher be upgraded and redesignated as headmaster with GP of so and so. However, the incumbent of this post should be senior most teachers of that school and should continue to take classes as in before. Now, this is important, Mala. See, the commission feels that at the level of LP and ME schools, there is no justification for differentiating the qualification of science graduate vis-a-vis arts graduate or any other graduate. Accordingly, the commission recommends that all graduate teachers in LP, ME schools should have the same GP 3,300. It is further recommended that all other teachers who have undergraduate qualification should be put at 2,500. So that translates to 8,400 and my lord 6,200, my lord. Now the pay anomaly committees, my lord, resolution at page 11. My lord may have the first, second, third, fourth paragraph, my lord. But the fact is that in case of LP junior basic school, there are no science, arts or any other graduate posts. These category of posts exist only in ME schools. The committee examined the minimum entry qualification required for various categories of post of teachers as per existing applicable service rule. The minimum qualification for teachers of LP school is undergraduate. Therefore, the scale pay of teachers, graduate teachers prescribed is not justified in case of teachers of LP schools. The anomaly committee carefully scrutinized the recommendation made by the previous pay commissions, and it is found that ROP rules 1990, 1998, there were two categories of pay scale for LP school teachers, trained and untrained. But under the 2000 ROP 2010, the LP school teachers have been classified under three categories: trained graduate teachers, trained undergraduate teachers, and untrained teachers. The pay scales of these teachers were recommended in the same pay band with different grade pays. That is grade pay of rupees 2,700 for trained graduate teachers and 2,500 for other two categories of teachers. Therefore, anomaly committee, in view of that, there should be a different grade pay for different categories of LP school teachers in accordance with ROP rules 2010. After careful consideration, the committee recommends grade pay of 7,400 for trained graduate teachers, 6,800 for untrained graduate teachers, including trained and other undergraduate teachers, and rupees 6,200 for untrained teachers under the ROP rules. Now, my lord can skip the rest, come to the next paragraph. In case of ME and other upper primary schools, the anomaly committee feels that there should be parity of pay scale amongst all teachers, irrespective of streams, arts, science, and commerce. Therefore, the anomaly committee recommends grade pay of rupees 8,700 to trained graduate teachers as applicable to science graduate teacher, because that's the only graduate post available. The committee also recommends grade pay of rupees 6,800 to untrained graduate teachers, including trained undergraduate teacher and untrained undergraduate teachers. The remaining teachers without training shall continue to get grade pay of 6,200. So, my lord, if I am a trained graduate teacher from 2006 onwards, I am getting the graduate scale of pay, both ME and LP. That position continued, and the pay commission recommends that pay. But anomaly committee, my lord, on a reasoning which is not based on records, have, my lord, reduced that payment. And subsequently, the amendment was made, which, my lord, I have challenged before your lordship. And this anomaly committee never heard me. And the anomaly committee is made if I have a grievance, not the employer having a grievance. Because the employer with open eyes had accepted the pay commission recommendation and then converted it into a rule, my lord. This is my humble submission, my lord, that this anomaly which has now been created, my lord, is required to be interfered with.
Yes.
Whether the present writ petition has been filed by teachers both from the LP school as well as the ME school. As per the new amendment, my lord, that the ME school is getting the, my lord, graduate pay.
ME school,
My lord, lordship may kindly have a look at para 2 of the writ petitions.
Yes.
No, they've made a statement, my lord, that they yes, in a synopsis, it has been stated. And my lord, regarding the particulars, my lord, what is their initial appointment? There is, my lord, not a single appointment has been annexed in the writ petition to show that, my lord, in which category they were appointed. Now the issue is, my lord.
They are coming out against an apparent anomaly created by your anomaly committee.
Lordship.
Don't go on technicalities.
Now here
What is the
the,
substance of the
yes,
matter?
my lord, on merit,
How do
my
you
lord.
explain this anomaly?
Lordship, here the issue is, my lord, why it has been now reduced, my lord. The reason is, my lord, in case of
Why you
LP
not
school.
required to hear them? In view of the fact that you have reduced, you have directed the reduction contrary to the recommendation of the pay commission, having accepted it.
My lord, thereafter it was again placed before the anomaly committee. Anomaly committee is a part of the, my lord, pay commission. If there is any anomaly,
If you are doing anything adverse to the interest of civil rights, the salary rights of a particular set of employees, are you not required to hear them at least in representative capacity?
My lord, in that case, my lord, till there, my lord,
Please just
subsequent.
stay your recommendation and then let the matters hang in uncertainty. What do you want? You want to rectify it at your own level by hearing them and trying to do away with the anomaly, or you want us to step in?
In that case, my lord, I will have to take instruction, my lord, regarding the
That
hearing.
is why we gave you the time. Rajasthan, things have been resolved.
That I can, my lord, within 1 or 2 days, I can have it, my lord. Lordship, that
Tomorrow,
tomorrow also, yes. My lord.
all right. You just came out and gave a statement. We have already done it.
Lordship,
You've done nothing.
and the
Gave you
relief
that
that has been,
opportunity only for this purpose.
my lord, if this order is passed in my case, I can have no grievance, my lord. This order will cover my cases. Because therein they got the benefit till the fresh decision is taken. That much only I'll be free, my lord.
That, my lord, tomorrow, only the.
Tomorrow. Okay.
In this case, Lordship, I was supposed to bring instructions. If Lordship is pleased to look at that impugned notice. That is a notice which was issued on 3rd of February.
Yes, please.
In exercise of power conferred by Section 3, subsection 2 of the Assam Prisons Act 2013, the Governor of Assam is pleased to notify a part of the transit camp, Matia campus, comprising of 8 blocks as temporary jails until further orders. So it is purely a temporary arrangement. Now, what is the situation? Why this temporary jail has to be declared? In the first week of February, Lordship, the government of Assam has launched a massive drive against child marriage. Massive drive. In some districts, it is about 31% also child marriage cases. So
Don't ask us to make a comment on that, sir.
No, I'm not making, but that the situation I am saying, ultimately Lordship will have to decide
That is
whether
a
we have
situation
done.
created by the government without anticipating what kind of infrastructure will be required.
Immediately, Lordship, about 6,000 cases were registered. 90% at the instance of the police, rest are from the private parties also. And we have made the arrest about 4,000 persons. 3,000 persons were remanded either to police custody or to, Lordship, the judicial custody. 3,000 persons. They were initially given place in the jails, but it was overcrowded because it is a sudden spurt of increase of the number of prisoners. So as a temporary measure, we have done that. These persons basically are the husbands. They are not hardened criminals. So as a temporary, out of 3,000.
State government think of it before taking this action, that they are not criminals.
No,
If
they are not
asking-
hardened criminals. They are criminals. They come under POSCO Act also. There are certain instances where the wives are below 12 or below 14. So they come under POSCO also. But they are not hardened criminals, just like the common perception about the criminals.
Has the same action been taken for tribals also?
Tribal?
Yes.
I have the figures.
Has this statistics?
Yeah, I have the statistics. Tribals, non-tribals, Hindus, Muslims, I have the full figure.
Okay.
Everybody is covered. It is not pick and choose from a particular community. It is not like that. I have the figures in my WhatsApp.
Okay.
So out of 3,000 arrested, 1,000 are already released on bail. So they are out. 2,000 are remaining. It is a matter of few days or few weeks.
So do you make a statement that only those
Only
who have been arrested in connection with this recent
exactly.
part of cases?
Yes, Lordship,
they are
I have it from later also to that effect.
Let us see.
Family issues.
Yes, that's right.
May I read it, Lordship? With reference to the subject cited above, I am directed to inform you that as a result of the campaign against child marriage during the first week of February, almost 2,000 people were arrested on 3rd February under various provisions of Prohibition of Child Marriage Act 2006, protection of so-and-so. In this context, after the arrest of the individuals, they were remanded to either judicial or police custody, and gradually the central and district jails located in various districts of the state started getting overcrowded. Accordingly, it became difficult to accommodate the increasing number of detainees, especially for Lower Assam districts. It is more in the Lower Assam, Lordship. As section 2 of subsection 2 of section 3 of the Assam Prisoners Act 2013, there is a provision to designate temporary jails where the number of inmates.
Communication, AG Sahab doesn't say that you will be placing only those persons who against whom you have taken action
Yes, Lord.
under this drive. If you can qualify this. maybe
My
you are
statement
justifying.
can be recorded. This is the instruction specific enough. Only those persons who were arrested for.
Without compromising the facilities which these detainees are entitled. Without encroaching upon their space.
No,
You'll be
absolutely. There are eight blocks. There are less than 200 persons. They are given 2 blocks. 6 blocks are used for this, and there is a
What is the
demarcation.
capacity of one block?
Total 3,000 capacity of the 8 blocks.
Can you specify what is the capacity of each block? Whether it is uniform, it is different, what is that?
I cannot, without incident, I cannot make that submission, but total capacity is 3,000
That
plus.
you stated, we understand. Yes, Mr. Council, what do you say? If they make a statement, they'll be reserving 2 blocks, and this is a stopgap measure, we can understand. Allowing the jails to be overrun by those kinds of persons against whom a sudden action has been taken. Sending them to jail would not be fruitful, actually. We feel that this action is, as a matter of fact, somehow or the other will not be creating so much of difficulty for those people. Maybe they'll get their remedy in due course of time in the courts of law. But till then, for them to be lost as ordinary criminals would not at all be justified. So if they can make a statement that 2 blocks will be reserved for your foreign nationals and the character of detention, etc., will not be changed. We feel that you should not be aggrieved then.
My lords, if it may please this honorable court.
What is the total number of?
Yes, figure is, Lordship, Adivasi is 203 arrested. Tribal is 276. One particular religion is 2,000. Others are 649. I have the complete figure.
No, the number of detainees.
Detainees. Today it is 2,000.
No, not detainees under these child marriage, declared foreign nationals.
Less than 200 in our affidavit we have.
You have said so.
Most of them were already released, Lordship, in terms of various orders of this honorable court.
My lords,
Yes.
if it may please this honorable court. My lords, if this honorable court would indulge me, I would seek to make submissions that the justifications of fact which have been placed before this honorable court today in no way can remedy the gross anomaly in law which has been committed by the state government today. My lords, I'll place 3 submissions in total before this honorable court. The first submission, my lords, relates to all 3 submissions relate to that devolution of power upon the state government relating to the detention center, my lords. Now, my lords, the learned AG has already placed the notification which is impugned before this honorable court. I won't go through it again. My lords will kindly have for a moment the Foreigners Act.
Yes.
The Foreigners Act, my lords, of 1946.
Foreigners Act. Yes.
I'm at the preamble, my lords. The preamble to the Foreigners Act. If I may read, my lords. The Foreigners Act, the Act 31 of 1946, is an act to confer upon the central government, certain powers in respect of foreigners. Now, my lords, will directly please come to section 3, my lords, of the Foreigners Act, subsection 2. Section 3(1) specifically says, my lords, that the central government has powers to make provision. Section 3(2) says, in particular and without prejudice to the generality of the foregoing powers, orders made under this section may provide that the foreigner Now, my lords will kindly come directly to clause E.
Hmm.
Shall comply with such conditions as may be prescribed or specified. Now, my lords will see under that, there are Roman numericals till 9.
Hmm.
All of these 9 Roman numericals, my lords, they lead to imposition of restrictions on personal liberty of foreigners, my lords. Foreigners is defined under section 2A of this act, my lords.
Hmm.
Now, the source, the constitutional source of these powers under the Foreigners Act, my lords, in my humble submission, is in list 1 of the 7th schedule, entry 17 to 19, my lords. My lords will kindly have the Constitution of
Yes,
India
yes,
for a moment.
carry on.
Yes. Now, my lords, insofar as the Foreigners Act and this entry are concerned, it is clear that the central government is the sole authority with who can exercise powers under section 2E.
Hmm.
Now, my lords, there's Article 73 of the Constitution, which says that the union's executive power is coextensive with the legislative power of the union. Now, my lords, if I may place one date before this honorable court, 19th of April, 1958. On 19th of April, 1958, my lords, there is a conditional entrustment of the union's executive power under Article 258(1) of the Constitution on the state government of Assam to exercise powers under section 3(2)(e). Now, my lords, I stress on the term conditional. This entrustment of power, the delegation of power on the state government was conditional, my lords. Now, for a moment, my lords, if I may place this notification, my lords.
Will you provide a copy?
Yes, yes, my lords, I will provide a copy.
Yes.
My lords, will kindly come to page 1 directly. Page 1, my lords.
Hmm.
This is the notification on top, my lords, the 19th of April, 1958 notification, my lords. My lords will see that here the president has entrusted to the government of each of the states of AP, Assam, etc., the functions of the central government. Under, my lords will see there are 4 Roman numericals.
Hmm.
At the end, at the bottom of this first notification, in making orders of the nature specified in clauses C, CC, D, E, and F of subsection 2 of section 3 of the Foreigners Act 1946 and the Foreigners Order 1948. And therefore, any of the Foreigners Order related powers, also executive powers of the central government, were also delegated, my lords. Now, my lords will kindly see the conditions at A, my lords, that in the exercise of such functions, the state government shall comply with such general or specific directions as the central government may from time to time issue. And that notwithstanding this entrustment, the central government may itself exercise any of the said functions should it deem so in any case. Now, my lords, there is a conditional entrustment. These are facts, my lords. Now, my lords will kindly come to the General Clauses Act, my lord, of 1897. In relation to what is the effect of a conditional entrustment, my lords. Section 3 of the General Clauses Act.
Yes.
Section 3, subsection 8, clause B, my lords.
Yes.
Central government, this is the definitions clause, the interpretation clause of the General Clauses Act, my lords. I'm reading 3(8), section 3, subsection 8.
Yes.
Central government shall, now I come to B, my lords, clause B. In relation to anything done or to be done after the commencement of the Constitution, mean the President, and shall include Roman 1. In relation to functions entrusted under clause 1 of Article 258 of the Constitution to the government of a state, the state government acting within the scope of the authority given to it under that clause. And here, my lords, is where.
It's reading 2(8)(b).
Yes, my lords. 3(8)(b). my lords. 3(8)(b).
Yes.
If I may read it again, my lords. Central
Yes.
government shall, in relation to anything done or to be done after the commencement of the Constitution, mean the President, and it shall include, in relation to functions entrusted under clause 1 of Article 258 of the Constitution, which I just read, my lords, to the government of a state, the state government acting within the scope of the authority given to it under that clause. Now, here, my lords, I'll pause for a moment and I'll make a submission, my lords, before this honorable court. The state today finds itself in a conundrum, my lords. The conundrum is this. Till date, throughout, my lords, and they will admit this,
Their position was that we are acting as the central government, which is evinced by the facts that I have presented before this honorable court. Today, they have exercised executive power as the state and placed themselves against the exercise of executive powers of the central government, which they were exercising till date. This notification,
In
which
relation
is,
to part of that structure.
yes, this notification which they are trying to justify, my lords, by saying that this is a prison and we have notified this under the Assam Prisons Act, which is a state act, my lords. By this, they have exercised an executive power.
Everyone just consider this thing, that they are required to provide you all kinds of facilities in terms of the Foreigners Act
Yes.
and the central government's notification to the extent of your requirements. You can't
Yes.
go around asking that the entire town of Guwahati should be left for the as a detention center.
That is not what I asked.
They are treating what they have carved out for you to be sufficient compliance. In that event,
Yes.
asking them to waste 3,000 space for just 200 persons would not at all be justified.
Certainly.
Looking to the limited resources available to us. So that
Yes.
is a reasonable exercise of power in my mind.
Absolutely.
To
My
our
lords,
mind, that is absolutely reasonable.
I bow down, my lords.
Yes,
This is correct. That once there is an establishment which is made for 3,000 people,
yes.
for me to say that we are 200 people to accommodate us there, it would seem at the outset, my lords, prima facie unreasonable on my part.
Yes.
However, my lords will kindly consider. I never asked for this, my lords. It is their discretion.
They acted with a vision of creating something for next 50 years. Then
Yes.
they think that, all right, we don't have the requirement for the entire infrastructure right now. So let us utilize it for different purposes. What is wrong in it?
Now, my lords, insofar as this is concerned, when I pointed out that there is a conditional entrustment under the constitution, my lords will kindly see what the conditions were, because as long as there is a fulfillment of the conditions,
Yes. All right, you've got a good set of arguments to address the court. We'll admit your petition. We'll hear it at length.
very well, my lords. My lords, sometime in the week commencing from Holi, my lords.
We'll see. There's no such urgency.
My
It's a
lords,
good academic exercise you want us to indulge in. Presently is not the time for it. We'll be entrusting you with more pressing requirements in the forthcoming days.
very well, my lords.
All members of bar admit respondents are duly represented. No one is for the Union of India. So they're duly represented. The notice will not be issued. List for hearing in the month of June.
Deeply obliged, Lord.
My lords, in the month of June, my lords, the issue is that this measure, if they, my lords, there's a certain factual issue as well. What have they said, my lords? They have said that there are criminals whom they are housing with me. Who are
Just hold on. Learned Advocate General makes a statement at bar that there are 8 blocks in the
Campus.
facility in the campus originally created as a detention center for foreigners having a total capacity of 3,000 persons. Presently, the strength of declared foreign nationals being housed in the
194 precise.
housed in the center is only 194. The state government, owing to emergent requirement of housing persons arraigned in connection with the drive against child marriages who are not hardened criminals, has considered in detail and exercised power to reserve 6 of these blocks for the persons against whom such prosecutions have been launched. As a consequence, 2 blocks having capacity of, make a statement, please.
Yes, Lord.
What is the capacity of these 2 blocks?
I'll give-
Capacity of so and so have been exclusively reserved for declared foreign nationals, and none of the facilities being provided to such foreign nationals shall be curtailed. In view of the statement so made, the writ petition is admitted. Yes,
In 10 minutes time, I'll give the executive number. Highly obliged. Lord.
Milords, this was an affidavit, Milords. I'm so sorry, Milords, for pointing out. We had brought this on record by an affidavit, Milords. The writ petition is already admitted, Milords. It's
We will
listed
file
for hearing.
appropriate
It's already-
affidavit in
Right,
position.
then the writ petition be listed for hearing, which has already been admitted, be listed for hearing in the
Milords,
month of June.
Milords, your lordship had pointed out it's a habeas corpus, Milords, sometime in the next month, Milords, because I'll not push for this month also.
Habeas corpus gentleman who is illegally detained.
Milords, the
Let us
foreign
go.
nationals.
Now let us go on that then.
Yes, Milords.
Yes.
Milords, the foreigners.
And furthermore, whether habeas corpus can be entertained in the form of a PIL.
Yes, Milords. Milords, this is not a PIL. We have, as far as my locus is concerned, Milords, I may place a judgment, Milords, in SP Gupta in 1982, Milords. It was clarified that in habeas corpus, the rules of locus standi are loosened, Milords. Now, insofar as my locus here is concerned, even if your lordship were to consider this as a PIL, there are sufficient powers under the PIL rules of this honorable
Then,
court.
all right, sir, tell us who is illegally detained.
The foreigners.
Are they not detained under the orders of the competent tribunal?
No, Milords. They are detained in a manner which is not in consonance with the conditional entrustment, Milords,
Maybe the
of the central
conditions under
government.
which they are being detained may not be satisfactory and compliant of the rules, but it can't be called an illegal detention.
Milords,
Then you would be required for improving the conditions of the center.
no, Milords. They cannot be kept in jails, Milords. Now, prisons,
It's not a
Milords.
jail. It's not a jail, sir.
Yes, Milords. Presently, they are housed in jails in 6 districts of the state, Milords.
They have already not been shifted
No,
to the
Milords.
center.
Not all of them.
I have to get the information, but there is sufficient space. There is no point of keeping them in the jail. That is why
So
we
then
have made
you
it.
Make a statement, sir, that all the declared foreign nationals will be brought into these two
Yes,
reserve
yes.
blocks.
In fact, we brought it. We brought everybody.
No, no, Milords. Everybody is not in, to my instructions, Milords. Everybody is not.
Maybe recent case, I do not know.
You get an instruction and.
Get an instruction, make a statement
Because
that
that is.
if anyone is left out, you please shift him here,
Yes, yes, Lordship.
him or her, whatever it is.
That-
That is
not
the
difficult
purpose
at
for
all.
So
creating
at
that.
2 o'clock,
Because this is a continuous process, Lordship.
we understand. We'll just post it tomorrow. You make a statement
Lordship.
so that you can otherwise also persuade the government officials not to keep any of these declared nationals.
That is precisely our reason, intention.
You understand? That is why the center was
Yes,
created.
Lordship. Yes,
To
Lordship.
use it.
It is a very, it is a fabulous construction, Lordship. It's a very nice, it is more look like a resort than a detention center.
Milords, tomorrow I'm very
No,
sorry,
no, this
Milords.
gathering would
I
like
think
to go and
the
stay there.
earlier Honorable Chief Justice visited that.
Yes, sir. Milords, I'm very, I apologize, Milords. I have an inconvenience for tomorrow, Milords, personally.
So all right, place it on 14th first.
Very well.
Simple.
Okay.
List
Highly obliged.
14th, that's great. You record the earlier part. Learned Advocate General praised that he needs some more time to seek instructions on the submission of the petitioner's counsel that some of the declared foreign nationals are still being kept in prisons. He assures that if the situation is so, the concerned officials shall be instructed to transfer such individuals to the detention center
Lordship.
immediately.
Lordship. Even today, there is 800 vacancy in that.
You fill the vacancy, sir.
You will have to create more for foreigners.
No, no, Milords. I do not have.
That we cannot do, Lordship. Or we have to invite
List on 14th.
immigrants.
14th.
I'm grateful.
Highly obliged, Lord.
May I please, madam? My lord, all the writ appeals emanate from a single judgment wherein all the connected writ petitions were heard analogously. This matter pertains to, my lord, a reversion of persons who were earlier working as surveillance workers, subsequently converted as LDA with government's permission. And after around 12 years of working, my lord, basing
Simple question, sir.
lordship,
What is the criterion for filling up the post of LDA?
LDA, it's in the same cadre, same thing. The
Different set of rules.
No, my lord, same one. That's what was missed out, my lord. If lordship can come straight to 168, my lord. My lord, we'll have, this is the amendment of the rules. We'll have, my lord, para 2 there, page 168, para 2. In the principal orders for the existing introductory paragraph, the following shall be substituted, namely, pending finalization of service rules to be framed in exercise conferred by the proviso to Article 309 of the Constitution of India, the Governor of Assam is hereby pleased to make
You
the
are
following
referring page number?
168. My lord will have item number 12.
Wherein they were sent to the work as Indians. Interim. What has been done?
There.
168, my lord.
Three official. Director. Legal.
Hearing if you're already.
The third member, they will go. Yes, skill and nominal.
No, they have.
Order was verified. That was of course a key. Where report after they
Then why you try to report it? Then I go to full over there. No, sir.
that would get to some where
They were as a matter of fact, they were selected as LDS. Maybe on the request of the employees, that they were not able to work in the full field posts. Kindly read para 28 of the impugned order.
Para 28. The court has given anxious consideration to the rival contention of the learned counsel for the parties. The core issue which requires determination is as to whether the action of bringing back the petitioners to their original post is justified. To answer the said issue, it is necessary to remind ourselves that the post of so-and-so is a post under a particular program called so-and-so is not a cadre post under the service rules of the health department. The relevant point which is required to be noted is that subsequent posting of the petitioners as so-and-so were in the same scale of pay as so-and-so and therefore cannot by any stretch of imagination be treated as a promotion. In any event, the post of SW being an ex-cadre post, promotion cannot be envisaged. Action of the authorities in permitting the petitioners to discharge duties as shopkeepers LD in the same scale of pay was mostly out of own request of the petitioner and due to administrative convenience. And by that, no indefeasible right to continue in the said post has vested on the petitioners. Now, my lord, I was brought to this post in 2004 of LD.
Maybe brought to the post and SW not being an encadred post.
My lord, that's what I'm saying, my lord, page 168. That was not placed before the honorable single judge.
And you have to file a review, sir, then.
No, my lord, this notification was there in the order, but this was maybe not highlighted before the
It
honorable
was
single.
there before the single bench.
Single bench.
Must not have been argued, sir, then.
But that's, my lord, unfortunately, maybe, my lord. My lord will have page
This
168.
is a notification of 2010.
10, my lord.
You were, all of your clients were placed as LDS in 2004. At that point of time, there was no encadred post for SWs.
My lord, this notification, SW, be the BHW junior assistant, all, my lord, in one cadre. My lord will have that principal orders 2, my lord. Serial number 2. Para 2, my lord. 1, 2, it's written on the right-hand side, top portion. In the principal orders, for the existing introductory paragraph, the following shall be substituted, namely, pending finalization of the service rules to be framed in exercise of powers conferred by the proviso to Article 309 of the Constitution of India.
Whether that exercise of finalization has taken place?
No, my lord. But this is the order that is being, my lord will only bear with me for a minute, my lord. Is hereby pleased to make the following service orders regulating the recruitment and condition of service of persons appointed as paramedical non-gazetted staff under the Directorate of Health Services Assam, including members of so-and-so and the non-gazetted staff under the Directorate of Health Services so-and-so. Now, my lord will have 3F, my lord. Member. Member means member of malaria workers, including persons working as so-and-so, so-and-so, and so-and-so, and all other grade 3 posts under the Director of Health Services Assam, Director of Health Services Family Welfare Assam. Now, my lord would come to the cadre, my lord, strength at page 170. strength of each cadre of service and scale of pay under the Director of Health Services Assam. 1 SW, 2 BHW, which my lord are involved here. Now, my lord, 8 junior assistant.
Yes.
So, my
That
lord,
would be
the
LDA.
lordship, LDA, my lord.
But
LDA.
whether LDA is a promotional post from SW,
No, my lord,
then.
it's not a promotion.
Then how does
Now,
it
what?
give you, how
Lordship.
does it prejudice you?
No, my
You are sent back from the post of LDA to the post of
My lord, what had
or
happened?
BSW as the case.
Now, what had happened in my case, my lord? It's true, I made an application.
Only thing which is pinching your clients is that they will have to work in field.
No, no, beyond that, my lord. It's gone beyond that, my lord. It's gone beyond that. My lord, what had happened was, I was an SW. I made an application to come to the post of LDA. This application was forwarded to the government. The government wrote back to the director, giving some criteria for examination. That was replied to. Thereafter, my lord, I was permitted to come over to LDA by ignoring the services that I have rendered as SW. I was the seniority, I was placed at the bottom seniority. Thereafter, my services were confirmed as LDA. My services were confirmed as LDA, and I continued as such, my lord. Now, what had happened?
Is that order?
Lordship, I place that. my lord. If my lord can come to, my lord, page 67, my lord. This is the government's order, my lord.
Page 60?
7, my lord, of the appeal memo. My lord would see, I am directed to refer to the letters on the subject cited above and say that government has no objection to change of cadre in respect of so and so to the cadre of LDA subject to the condition.
Mr. Nair,
Lordship,
the question which would arise is,
lordship.
on the date this order was passed, there was no encoded post of SW or BSW in the rules.
My lord,
So you were posted
lordship.
in the cadre of LD, thereby reducing the cadre strength which is available to be filled by way of direct recruitment.
Lordship. Lordship.
So you chose to work on a office posting, a table posting, as against the field posting which you were required to perform field duties in as a BSW. That is what was of your own choice. Now, since you were not in the cadre and on that very day, how would you get a
My lord,
indefeasible right
my lord, this
to
post,
hold on to the post?
my lord, these posts on that day were not under the, my lord, scheme. It was under the government. And pay commission was, my lord, fixing the pay of those posts. It is, my lord, that's the mistake, my lord. That's an error which has crept into the judgment saying that these are under the, my lord, scheme. No, my lord. These are under the Directorate of Health and Family Welfare and Services, my lord. There is a directorate called Health and Director of Malaria. These form within that state cadre, my lord. And these are all, and my lord, my GPF was being cut, my lord, from 2001 onwards. I've been paying GPF from 2001 onwards. I put that documents on record. Now, my lord would say, here the government had given its sanction. Thereafter, by saying, my lord, you'll only have page 67, my lord. I did not, my lord, change of cadre, my lord, can be done if the government agrees to that. Now, my lord would see here, my lord, I am directed to refer to the letters on the subject cited above and say that government have no objection to the change of cadre in respect of so and so to the cadre of LDA, subject to the condition that is seniority as BHW will not be counted in the cadre of LDA. I joined in the bottom, whoever there, I joined in the bottommost. Then my lord would see my confirmation at page 77. My lord. The following incumbents attached to the office of the Joint Director of Health Services, Malaria, Assam, Guwahati are hereby confirmed as shown against them with effect from 1/9/2012. I was confirmed, my lord. Then what had happened, my lord, exactly was, my lord would see the manner in which these orders were passed. If my lord finds that they were passed in the terms that is being projected, my lord, I may not have a case. Now, my lord will come to page 80.
Yes.
There was a gentleman called, my lord, Biro Prata Hacharji. He was suffering from some spinal problem. So he approached this honorable court saying that kindly accommodate me against the post of LDA. This honorable court, my lord, the order is 13/6/2013.
Right.
After recording everything, my lord, the last line, my lord, of that page 80. In view of the above, this writ petition is disposed of by directing the respondent number 1 to take a final decision in the matter with a period of 1 month from today. Final decision with regard to his posting. Now, my lord would see the order that has the impugn order at page 84, my lord. In pursuance of government letter number so and so dated 13/8/2003, issued on the strength of the order dated 13/6/2003. The honorable court's order passed in WPC number so and so and HLA so and so by the honorable court. The following LD assistants working under the establishment noted below against each incumbent whose original application were so and so and subsequently were converted as so and so. So and so are reverted back to the post of surveillance worker at the earlier shown below. Now, without any notice, saying that it was, my lord, on the basis of directions passed by this honorable court. This honorable court never passed the direction. Now, my lord would come to the impugn orders mentioned therein, my lord. That is at page. My lord would find it at page 98, my lord. The orders of the government which are reflected there, my lord.
Yes.
My lord, this is the first order, 13/8/2013. I am directed to refer to the Guwahati High Court, Honorable Guwahati High Court order dated passed in so and so and inform you that in absence of any provision conversion in the service routes, this department regrets its inability to agree to conversion from the post of so and so to so and so. This was returned to the petitioner specifically therein. That will not convert you.
The petition that
writ petition, my lord. Now, my lord, the next page, my lord. Now, my lord would see the problem here. This is of 28 April 2014. With reference to the department's letter on the subject cited above, I am directed to say that the government has already regretted its inability to agree to conversion from so and so to so and so in respect of Biro Prata Acharji so and so. In spite of clear instructions from the government, you have placed B. Acharji as LD assistant under disposal of the district malaria office, Karimganj White order dated so and so, which is illegal and unauthorized. You are therefore directed to cancel the order issued in respect of so and so, along with all such illegal unauthorized order immediately and communicate it to all concerned to take steps accordingly. Now, what had happened, my lord? In spite of the order at page 98, the director placed him as LDA.
Yes, LD.
The government said, we said, don't do it. How could you have done it? It is in that line, my lord, this order was passed. It has got nothing to do wherein, my lord, these transfers were with the
Approval of the government.
Express approval of the government. And my lord, our seniority was taken away from us. We joined and we were confirmed subsequently, my lord. And these orders were never passed, my lord, by hearings. Now, my lord, the honorable single judge, what was projected before the honorable single judge was, my lord will see the submissions made by the departmental council, my lord, page 149. See, so and so at the page 149, para 18.
Yes.
See, so and so submits at the outset that though affidavit in opposition has not been filed in all cases, those filed would cover the other cases as well. The Learned Standing Council submits that it is the direction of this court which forms the basis of the decisions to repost the petitioners as SWBHW. He clarifies that the word reversion has to be understood in the facts and circumstances of the case, wherein there is no change in the pay scale of pay or other service benefits, and therefore by such reversion, no legal rights of the petitioner have been adversely affected. That being the position, the aspect of following the principles of natural justice become redundant. Sri Gogoi elaborates that it is only when an adverse action is taken against an incumbent, the aspect of following the principles of natural justice would come in. And in the instant case, no adverse action has been taken against the petitioner. Now, my lord, that writ petitioner who was before this honorable court, he again approached this honorable court sometime in the year 2015, and that decision occasioned in 2019. Therein also, my lord, there was no reference that there are illegal orders earlier passed, reverted. The honorable court only said that in future, my lord would have it at page 150, para 20, my lord. However, this court made some additional observation in the aforesaid judgment and order dated so and so, which is extracted herein below. However, before parting with the records, having noticed that the officials under the so-and-so has converted the posts of several surveillance workers to LDA junior assistant or stroke keeper, and the learned standing council has submitted that one wrong in the past cannot be a ground to commit another wrong. Moreover, in the affidavit in opposition, the respondent number 2 has cited that there are no rules permitting such conversion.
To this extent, he was right. There is
Fine.
no such provision that
Fine, fine.
the cadre can be changed.
Fine, my lord, but there is a provision under FR 15, my lord, wherein the government can always, my lord, transfer a person from one post to the other. But the approval of the government must be there, my lord. Now, therefore, it is made clear that if in future any such conversion by the respondents comes to the notice of the petitioner, if so advised, he shall be at liberty to approach the court again to ventilate his grievance and claim to be treated equally and or at par. So this was the only observation made by the Honorable Court, that too in 19. So an order passed in 2016 is thought to be justified by the directions which are there in an order passed, my lord, in 2019. My lord, and the scheme thing, my lord, is totally not the whole thing went in that. And now, my lord, after the 7th pay commission, my lord, a difference has occasion now. Now, unfortunately, that was also not brought to the notice of the Honorable Court. My lord, earlier the post of BW, SW and junior assistant were in the same pay pattern. Now, my lord, it has changed. Now the LDS have been placed at 6,200, which I am drawing at present. And the post of, my lord, SW worker is 5,400. 5,600, sorry, my lord.
That is after 7th pay commission.
After the 7th pay commission.
This was, as a matter of fact, not the argument before.
Unfortunately, my lord, although that was available before that was in existence, that was a facting issue on that day, this was never placed before the Honorable.
The next quarter for the rule, that is what they. I think this. Yes, it is what you say. Apparently, the rules have been skipped. The rules, the post has been made an uncarded post. And who is to fault? They filed an application, you could have rejected.
Yes.
You're not even
Because
posted them, you have confirmed them. And by making them to lose the seniority.
exactly, Lordship. When the people on our side are hand in glove with him, then this can always happen. And this
But
happened.
Whether can you rectify it after 15 years?
Definitely,
to
Lordship,
the
because
predicament and to the financial loss of the employee.
absolutely no. Protection is given. There is absolutely no change of service condition except his post.
Change of service conditions will come around because the pay scales have changed with 7th pay commission as.
That Lordship, if Lordship directs, it can be, it can be protected. No difficulty on that.
How can it be protected, sir? How can we direct that you give the pay scale of an LDA to a SW? Which is not.
Now, Lordship, first we have to go to the root. What is your Lordship? He has not shown his appointment letter. He entered into service as a seasonal worker for 90 days.
We are not into that dispute.
But that is a part of the record. That is a part of the record.
That was never the objection before the, then you should have said that we'll shunt them out of the service.
No, we cannot be up to that harsh.
Then there is a question.
At least now one thing, he is eating up the post of the LDAs
Yes.
in the channel where the LDAs are supposed to get promotion or the junior assistant. He is entering into their domain.
He's entering into.
That is number one.
You permitted him to do so.
We permitted them, when we have realized that a mistake has been done, does the government do not have the right to rectify its
Without
mistake?
hearing,
Lordship,
without hearing.
here it is because there is no adverse situation created for him.
Situation, he just. pointed out
Except he
pay
is working,
Pay scale.
that I
Pay
am
scale
committing, I am,
Feature of right of promotion.
he is not there, Lordship.
You permitted him to enter, sir.
We allowed him to work in as a LDA in 2012.
Expressly, not 2012, 2006. And you confirmed him in that.
In 2012.
Post. Just
Now-
hold on. Please repeat that order. There is the order, page 68.
Lordship.
Please read page 68, sir. This is not any official of your department. This
My
is
lord,
the Undersecretary
67.
to the government of Assam.
I am directed to refer to the letters of the subject cited above and to say that the government has no objection to change of cadre in respect of so and so to the cadre of LDA, subject to the condition that his seniority as BHW will not be counted in the cadre of LDA.
So he waived. He's in.
Waived only seniority. He waived the
No,
seniority, but you.
no,
took the
Lordship
cadre of
will
LDA,
kindly
sir.
have to see. We have seen there is total mismanagement in his service career. He entered as a temporary worker, then he worked as a surveillance worker, then he worked as a basic health worker. All these things are there interchanging. And he did not enter it through a recruitment
With
process
this
also.
order of 2004, everything has been set.
Lordship,
rest.
if I disclose how the health department, how the education department functioned for last 15 years.
You have the opportunity to improve the things now.
Now, we are improving in.
You can't go back.
No,
in
we are
history.
improving it not from today. We are improving from 2010.
You can't go back in history.
We can,
Recommend to the detriment of the
no,
employees.
no difficulty, Lordship. There are several cases. So Lordship may
We will
fix it.
admit them. We will hear you.
Yes, Lordship.
Bring out a solution.
Yes, we'll
A
find out.
reasonable solution.
But
Maybe you can.
only in his case, there is a confirmation order. Others, there is no confirmation order. Number one. There are huge differences amongst all the facts.
We'll see. We'll see.
We'll
first.
see.
We'll admit this one then.
Lordship, in the month of June, let the hearing.
We'll hear them. You want us to take the writ petitions individually?
Only this, his case will be a little bit different.
Raja
Factually.
Sharma.
Raja
is
Sharma.
different.
He is the smartest one.
Are having the correct strings to pull.
Absolutely, Lordship.
I'm sorry, I have appeared for the appeal 11, item number 11, and 14 to 19.
Let us admit all the writ petitions.
All the, yes, Lordship.
Admit, the respondents are duly represented. Pleadings are complete. The addendum stay order dated so and so is confirmed to last the disposal of the appeals. List the appeals for hearing. On.
But stay order may be considered.
We have confirmed. On 8th May.
8th May, Lordship. Highly obliged, Lordship.
My lord. Herein the honorable single judge, my lord, had accepted all my contentions. But still, my lord, my seniority was directed to be lowered. Now, what had happened here was, my lord, we were working in the department on ad hoc basis. We appeared in the selection process, we did not succeed. We approached the government, my lord, by way of a cabinet memorandum, relaxed the provisions of the rules or the service orders, and my lord appointed us on regular basis against promotional quota with effect from 16/11/2000. In the moment, my lord, the selection process that was underway was, my lord, completed. The APSC had forwarded the select list in the month of July 2000. But, my lord, for some reason, those appointments did not take place. The appointments from that select list took place in 2001 and 2002. My senior is representing those. But they were the petitioners before the court. Now, my lord, that regularization was challenged before this honorable court in a writ petition, which was dismissed by persons who were there below them in the select list. My lord, below them, they said, why bring in these people? Those vacancies be utilized to accommodate us. This division bench, this honorable single judge rejected the application. The division bench, my lord, also rejected the writ appeal. It went in appeal before the Supreme Court. The Supreme Court, my lord, on examination of the matter, my lord said that the relaxation that has been done properly. The regularization of our services is proper.
Okay.
So, my lord, I am born legally in the service on 16/11/2000.
Okay.
Now, my lord, there were gradation lists published. Initially, my lord, a provisional gradation list in 2017, which was finalized on 1/10/2019, wherein, my lord, we, the appellants, we were placed above them, 37 to 52, and they were from 53, my lord, they were from 54 onwards. This was put to challenge before this honorable court. And their basic prayer, although my lord, neither my appointment nor my lord selection regularization was put to challenge.
That could not have been in view of the fact that the Honorable Supreme Court has put a
Seal of approval to it.
seal of approval on that.
Now, my lord, their case was that in view of the fact that the appointments made by us have been made in violation of the rules. So we cannot claim seniority over them. Now, the honorable single judge, my lord, in all with due, my lord, submission, if my lord can come to the conclusions reached by the honorable single judge, which my lord would find. Page 208, my lord, para 13, my lord.
1-3.
1-3, my lord. 208 of the appeal memo. my lord. Earlier, the submissions have been recorded. Paragraph 1-3, it's called, when it starts with the bold letters, date of appointment and date of regularization. As indicated herein above, there is no dispute at the bar that the names of the petitioners appeared in the select list published by the APSC on so and so. And they were initially appointed for a period, 2-year probation period on various dates in the month of March 2001. Nonetheless, it has been projected by the learned senior counsel for the petitioners that as per clause 10 of the 1994 service orders, it is provided that seniority of a member of the service shall be maintained in order of their respective position in the select list prepared by the Assam Public Service Commission. Then, my lord, 15, my lord. However, from the statements made in the affidavit in opposition filed by the state government, respondent number 1 to 5, it has been mentioned that on being appointed under regulation 3F, the respondents number 8 to 15, the appellants before your lordship now, had respectively joined their different dates between so and so. However, the dates of regularization was with effect from 16/11/2000. Now, my lord may come to paragraph 21. Twenty-one. 212, madam. As mentioned herein above, the names of the petitioners appear in the select list published by the APSC on 17/7/2000. As per provisions of clause 10 of the 1994 service order.
Just would like to pause here.
Lordship.
When they were selected in the year 2001, how their names appeared in the year 2000?
No, my lord.
Please come back to that para 30.
Lordship. My lord, the select list was prepared in 2000. But the appointments occasioned into March 2000.
Select list was issued.
Lordship. But they were born in the service from 2001 and in 2002. my lord.
It was the same selection process. Yes.
Then, my lord, the honorable 212, my lord, I was referring to. As mentioned herein above, page para 21, my lord. As mentioned herein above, the names of the petitioners appear in the select list published by the APSC on 17/7/2000. As per provisions of clause 10 of the so and so, the order when the date when the petitioners had respectively joined their service is not material, because the seniority relates back to the order in which their names appear in the select list. I'll place that, my lord, rule order 10. However, notwithstanding that the respondent number 8 to 24 had joined on different dates between so and so, but their services were regularized with effect from 16/12/2000. Now the finding on our services, my lord, at page 215, para 27. However, in the present, my lord has got it, para. However, in the present case in hand, on facts, the regularization of the respondent number 8 to 24 herein has been upheld by the Supreme Court of India in case of Mukul Soikia. Therefore, as the respondent number 8 to 24 have become member of service of cadre of CDPO superintendent so and so under the 94 service order with effect from 16/11/2000 by virtue of the decision rendered by the Supreme Court in the case of Mukul Soikia, the ratio of the cases cannot be applied against the respondent number 8 to 24 on the ground that it would not be in connivance with its well-settled dispute. So, my lord, the honorable single judge records a finding that I became a member of the service with effect from 16/11/2000. Now, my lord, having recorded that submission, my lord would see how the matter went further. Para 32 to 19, my lord. 219, para 32, my lord.
Yes.
Thus, it is seen that in case of Mukul Soikia Supra, the Supreme Court of India had upheld the regularization of the service of the respondent numbers 8 to 24 upheld the decision of the government to relax by invoking clause 11 of the 1994 service order. Thus, both the points decided by the Supreme Court of India has attained finality. The observation, my lord, may skip it. Now, in spite of this conclusions, my lord, the Honorable Single Judge in para 34. Now, my lord, the seniority has been decided. It is seen that the cabinet had taken a decision on 30/10/2000 to regularize the services of the respondent number 4 to 24. It has already been observed herein above before that irrespective of the dates of joining in terms of provisions of clause 10 of the so and so, the seniority positions of the petitioners would relate back to the order in which their names appear in the select list published by APSC on 17/7/2000. Although the respondent number 8 to 24 joined on different dates between 1/6 to so and so, but their services were regularized with effect from 16/11/2000.
The order whereby you were absorbed in service.
Lordship.
At November 2000.
16/11/2000.
16/11.
Lordship.
Can we have a look at the order, please?
I'll just place it. My lord, I'm sorry, my lord, that order is not a part of
Crucial, what is the language of the order, that order?
lordship,
Whether
lordship.
your absorption in service relates back.
No,
to the date you joined?
no. 16/11/2000, not a date before that.
Let us have a look.
My lord can have, I am not there from a date before that, my lord.
Very
My-
well then, all right, continue.
I'll place that one before you. Lordship. It will. Then, my lord, the Honorable Single Judge,
Yes.
my lord, para 36, that answer what?
That your argument is that the seniority has to be reckoned from the respective dates on which they had entered the service.
No.
Now, what you said, look at para 37. please.
Yes.
No, my lord, this was not never my argument, my lord.
This is your argument.
My lord, I
Yes,
have my pleadings, my lord, I have my, I'm sorry, my lord, if that be so also. My argument was that my seniority should be from 16/11/2000
Right.
and their seniority from the dates when they were born in service.
17.
My lord has got it. So before a date they were born in service, they are not entitled to seniority. They were appointed, my lord, in 2001, 2002.
Let us see the rule then.
Rule, my lord will now come to the rules, my lord. My lord, we'd have page 113, my lord, order. It was an easy now.
113.
113, madam. It's called, my lord, the Assam Social Welfare Recruitment and Promotion Service Orders 1994. 2, my lord, 114. Definition. My lord, we'll have 2H. Selection list means the list referred to in para 7(3) of these orders. My lord will only make a note of that. Now, my lord would come to 7 at page 116. It's general procedure for promotion.
Yes.
My lord has got it.
Yes.
Before the end of the shall make an assessment of the likely number of vacancies to be filled up by promotion in the next year. Now, 3, my lord would find at 117. The appointing authority shall simultaneously require the committee to recommend within a month a list of officers found suitable for promotion as per provisions of the cadre in order of selection in respect of promotion made to the each cadre in which recruitment is made by promotion. My lord would see now 10.
Yes.
Order 10. The seniority of a member of the service in a cadre shall be according to the order in which one's name appeared in the selection list. If one joins the appointment within 15 days from the date of receipt of the order or within the extended period which shall not in all case exceed 3 months. Now, my lord, although from the reading of the rules, this is only pertaining to promotion, my lord will say that this will also pertain to direct recruitment. My lord, that list which is prepared by the APSC, it would be the final list of merit intra the candidates appointed from that batch. Because what happens is, my lord, there are reserve candidates who, my lord, may be appointed in March. The other general community candidates may come, OBC candidates may come in June, July, August, according to the
Seniority would
vacancy
be reckoned from the date of issuance of the list.
list. So, my lord, there not the date of record, not from the date of issuance, but the seniority, but the merit positions
Merit
assigned in the list.
Yes.
This cannot be the appointment, my lord. They will be born in the service on the date they are appointed. And their appointments, my lord, occasion, my lord, I have given a few appointment orders in my, in the writ also, my lord, in my lord, affidavit in oppositions also. They were all appointed, my lord, after November, or they were not even appointed in the year 2000. They came, my lord, in 2001, 2002. So from the date they were appointed, they will be entitled to their seniority. And I being, in virtue of the Honorable Supreme Court's order, there from, my lord, 16/11/2000, my lord, my services, my seniority could not have been, my lord, undermined. My lord. The Honorable Supreme Single Judge approved that I will have my seniority from 16/11/2000. Now, having recorded that submission, he could not have, my lord, depressed my seniority in relation to a person who came into born into the service after that date. My lord.
Or learned single judges held that in view of this judgment,
Lordship,
their appointments have also been upheld.
which one, my lord?
Para 36.
Respondents. These are the respondents.
No, my lord, if this is my lord, my
This is
appointment.
the respondents' appointment.
I was the respondent therein, my lord. The regulation of service,
Which has been given is non-reflection of the names of the respondents in the select list,
Lordship.
in the APSC list.
But rather, my lord, the Honorable Supreme Court's decision, Mukul Saike, if I may place that, my lord, I've given a copy.
The copies there.
Or the copies are there.
Copies there.
Therein, my lord, it has clear. Book it up. Book it up. My lord would find therein the APSC had, my lord, subsequently regularized or confirmed that list, my lord, in our case also. And the Supreme Court has noted that also.
Which list?
My lord, the decision to regularize us
Yeah.
had also gone to the APSC, my lord. And APSC had given its concurrence to that list.
Where is that report?
My lord would find. I'll just place that, my lord. I'm sorry, I don't. I'll just get my book, my lord. One second. My lord, will just give. Hmm?
391.
My lord, para 22 of that judgment, my lord.
Para 47.
22.
Para 47.
392, my lord. It is also submitted that subsequently by notification number so and so, APSC has also conveyed its approval to the regularization of the respondent services. They have stated that the procedure for regularization of services was a one-time measure adopted by the state government in the special circumstances, and their regulation has not in any manner caused any prejudice to the interest of the appellants. So, my lord, that order subject order 10, with my humble submission, would come into operation after the appointments are being made, and intra that select list persons, how their seniority would be determined would be in terms of the merit position obtained therein. It cannot mean, my lord, that even before
That is not, but this selection for these is the respondents.
That is what has been heard.
So now the issue is that
2022.
no,
That was in
these persons, they join such.
It was in
They would not consider born in that. He's right, I'm saying that only in class 16,
All those selected candidates on the date of that, not the date of. Within that. Within that.
Yes, please.
My lord,
Mr. Chaudhary, the reasoning is not convincing on the face of it. The
My
argument
lord-
that your clients were not even
My
born
lord,
in service.
I'll
There
pers-
are two different
No, my
procedures.
I'll
through which-
persuade your lordships. The conclusion will remain the same, reasoning may differ.
Very good.
First of all, my lord, my learned friend had made two wrong submission. First, he said that their regularization was upheld in Mukul Saikia. No, Mukul Saikia, the issue was different. And secondly, my lord, their regularization was never approved by APSC. My lord, in the same selection process, they participated and they failed. And in fact, their backdoor entrance, my lord.
Irrespective. we
No,
are not
no, my
supposed
lord.
to Go into that.
No, my lord, I'm very sorry to say, in the Mukul Saikia judgment, Honorable Supreme Court has made certain observation. I would respectfully submit after Uma Devi, how these observations could have been made, I don't know, my lord.
We are
I can
not-
only make that much of submission,
We-
nothing
we-
beyond that.
We don't have even a
Anyway.
semblance of doubt that we can
Yes,
enter into what has been said.
my lord, I'll say
Para
that.
47 state of.
Now, my lord, will
Please,
kind,
please come straight up to para 47 of.
no, I'll come. Please, lordship will finally give me, my learned friends are good for more than half an hour. Let me get 10 minutes time.
Give me ample time,
Yes,
but
yes.
please bear with us.
Yes,
Para 47.
of the judgment, my lord.
Yes, Mukul Saikia.
Para 47. My lord will read para 10 of Mukul Saikia.
We will
First,
read all paras, sir. Don't worry.
and 48 also.
who is these appellants? The appellants who had no local, absolutely the Supreme Court was right in saying this, the appellants before the Supreme Court had no locus standi. Not we, my lord. We never challenged their regularization. What, my learned friends should place the facts in perspective.
Sir, please read the para once
Yes.
carefully.
In these circumstances, High Court is right in holding that appellants have no locus standi to challenge the regularization of private respondent against the vacancies meant for promotional quota. The appellants who appeared in the interview held by the APSF direct candidate could not have any grievance against their regularization against the 40% promotional quota. My lord, how this paragraph help them, my lord? Or how does it help me? It helps none of us.
Regularization of the respondents.
No, my lord, whether that
has
was a
received the seal of.
my lord,
approval
that's
from
why,
Honorable
that's
Supreme Court.
why I have brought the constitution bench judgment. A mere sentence in a judgment is not a ratio decidendi. I have brought the judgment, my lord. I knew it
Sir,
will be
this is
required.
not a mere sentence. This is the declaration.
No, my
that
lord.
The regularization.
No, I'll satisfy. Please come to Paratin.
You want us to interfere in their regularization now?
No,
At this stage?
no,
Then-
no. My lord, their regulation may stand, but they will not gain seniority. That's the case. Rafiquddin's case, Supreme Court has clearly said that. AK Bhatnagar's case, Supreme Court has clearly said that. Mukul Hazarika, Supreme Court has said that. My lord will kindly come to paragraph 10 of Mukul Hazarika.
Yes.
Sorry, Mukul Saikia.
Yes.
Respondents appointees submitted that since they were not regularized against the post advertised by APSC by means of advertisement dated 1997, the appellant could not claim that they should be appointed against their selection was taken by the state government by giving relaxation as contemplated under clause 11 of the so-and-so. And the said decision in fact has not been challenged by the appellant. Original writ petitioner is either in the writ petition or in the writ appeal filed by them before the High Court. So my lord, this matter traveled to Supreme Court from this honorable court. Now they submitted before the Supreme Court that our regularization was never challenged. What was claimed was, my lord, they were down below. There were more vacancies and their names appeared in the select list. Therefore, they claimed that after filling up the 27 posts, there are still vacancies. Please consider our case. That was the writ petition, my lord. There was no occasion for the Supreme Court to make any observation on their regularization because their regularization was never challenged. Now, my lord will kindly come to paragraph number.
Can we put a query?
Yes,
Your clients
yes.
were selected against those 27 vacancies.
Yes. And we were selected and were above, they failed. In the same selection process, they also took part, they failed.
They were already working.
They were three
Maybe on
backdoor
contractual
entries,
basis.
backdoor entrance, my lord. My lord, if their claim is to be accepted, then in every case, lordship will have to say that the seniority has to be counted from the ad hoc appointment. No. How can it be possible, my lord? When, especially when after Uma Devi, my lord, how can this judgment could have been there? Now, my lord, you kindly come to para 36 of the Mukul Saikya. The cabinet in the meeting held on 13/10/2000 decided to regularize the services of private respondents in the special circumstances that they have been working against the post of CDPOs for the last more than 4 years, and their performance was found satisfactory, and their continuity in the existing post also need for effective implementation of the time-bound scheme of the government for which ICDS projects were provided in the state of Assam. Pursuant to the cabinet decision, notification was issued by the commissioner and secretary to the government of Assam Social Welfare Department, by which the services of the appellants were ordered to be regularized with effect from the date of joining the Social Welfare Department. Indisputably, appellants have challenged only the cabinet memorandum dated 16/6/2000 in the writ petition before the High Court, while the cabinet decision dated 13/10/2000 was taken on the basis of said memorandum. The subsequent notification regularizing the services of the appellants issued by the respondents on one had remained unchallenged. Now, my learned friend has made a statement that regularization was upheld by the Supreme Court, but there was no occasion. All that Supreme Court said was to these appellants, Mukul Saikya and others, since they were regularized against promotional quota, since the select list has exhausted, you have no right. That's the only point decided in Mukul Saikya. Nothing else, nothing more, my lord. How can my learned friend argue based on the judgment that an indivisible right has been recognized by the Supreme Court? Where is the occasion? My lord, I'll show two more things, my lord. If your lordship would kindly come to the cabinet memorandum at page 91. Page 91, my lord.
Yes.
During the year para 1, during the year 95-96, pending selection to APSC, 26 persons were appointed as CDPO, Superintendent of Home, Provision Officers under Regulation 3F of the APSC Limitation of Function. Out of the 26 candidates, 16 candidates could not come out. These are the 16, my lord. Could not come out successful of the written examination held by the APSC. They were unfit candidates, my lord. We could not clear the exam. Now, my lord, the file was processed at different levels. My lord will kindly come to page number 99. This is the view of the, my lord, LR. And I'll come to the view of the APSC. Para, page 99, bottom, my lord. This is the part of the cabinet memorandum.
Yes.
Last para, under item 22 of the second schedule of the Assam Rules of the Executive Business, government can act otherwise than in accordance with the advice of the APSC if such a proposal is submitted before the cabinet and same is approved. But this does not mean that the cabinet has the power to regularize the services of 3F appointees without consultation of the APSC. No regularization in exercise of executive power is permissible because this practice not only violates the mandate of Article 14 and 16 of the Constitution, but also denies to all the eligible candidates their legitimate right to apply for the stand for selection and get selected. In view of the above, services of 3F appointee can only be regularized in consultation with the APSC. Now kindly come to the last portion, my lord, the APSC's view. APSC declined. Now, my learned friend made a submission that it was approved by the APSC.
Even if it was done as observed in Mukul Saikya,
yes,
the order was in 2006.
Yes, my lord, kindly see. In inviting a reference to your letter cited above.
The order of APSC on record.
My lord, this is the view of APSC.
No, if the order which you are referring to in Mukul Saikya, 2006, is it on record?
No, my lord, it's not on record. And
My lord,
this, my lord, if I may just point out.
My lord, may kindly come to
wait.
page 100.
Yes.
In inviting a reference to your letter cited above, I am directed to say that the commission regrets their inability to regularize the service of the appointee under Regulation 3F in view of the standing select list, and it is necessary for the incumbent working under Regulation 3F to take part in the process of selection for appointment on regular basis. My lord will kindly see, here is a case they participated in the selection process along with us. They failed. Government showed a favor to them, my lord. It doesn't favor, my lord, which Supreme Court has upheld. My lord, now question is, the regular order 10 of the service order says how seniority would be determined. Right. Senior, my lord, that's why it is said, who can become a member of a service or a cadre? One who bonds into the cadre in accordance with the recruitment rules. Has they born in the cadre in accordance with the recruitment rules, my lord? My lord, B.N. Nagaraja's case, Honorable Supreme Court way back in 79 said, my lord, when Article 309 is holding the field, executive power under 162 cannot be invoked to regularize anybody's service. My lord, I'm relying on that B.N. Nagaraja's case, which was referred to. My lord, and Lordship is absolutely correct. My lord, even we'll have to also file an appeal against this single judge's order. After reading yesterday, I could also notice. Now, my lord, in one of the case, my lord, which is under appeal, the same learned single judge has held, a 3F appointees have been given seniority over regularly selected candidate, my lord. What to do, my lord? Where do we go? Where do we go, my lord? Now, in this case, my lord, where is the legitimacy of this appellants, my lord? Who are they? They are backdoor entrants, my lord. They should have been shown the door by the government. Now, my humble submission is, my lord, if their case is based on, my lord, now, all right. My lord, in Rafiquddin's case and in Bhatnagar's case, which I'll rely, my lord, Honorable Supreme Court has said, all right, Supreme Court has made certain observations regarding your regularization in Mukul Sakya. Therefore, very well, you may go ahead with your job. But there is no question of gaining seniority because you are never entered the service in accordance with the rules. And my lord,
Struts, as we could understand now after arguments, that these persons, they appeared in the same selection process.
Yes, they failed.
And your clients and failed.
Yeah.
And now they want a seniority above
over
you.
us.
That is what is really crucial as per us.
Exactly,
Yes.
my lord.
Oh, that regularization may have been a principle. The question would be whether they can be in the seniority list unless their names appear in the APC.
The pending of the learning.
And my lord, regularization is not a mode of recruitment.
That's right.
That's why I said, my lord, after Uma Devi, how, my lord, in Mukul Sakya's case, those observations, though it was in the.
We are not
And
supposed to
my
go
lord.
into how.
So, my lord, therefore,
how
my
the judgment.
humble submission is, my lord, the learned single judge, yes, could have, my lord, written the judgment in a much better way. It has not been done. That I do not dispute, my lord. And in fact, my lord, this is not the point which learned single judge would have taken. My simple case was when Article 309 is holding the field, where is the scope of the cabinet invoking 162 power?
We can't go into that decision now, sir. That's too late in the day.
No,
Once that decision has been examined by Honorable Supreme Court, there
Yes.
is no occasion for
No,
this
no,
court to
it
make
will be wrong to say the Supreme Court examined that, my lord. Those are only casual observations. my lord.
Maybe even with the auditor of
Those are
Supreme Court
binding.
is
Binding.
on this court.
No, therefore, we are not questioning their appointment.
You're
If somebody,
benevolent enough.
if somebody questions their appointment, those observations will come handy.
Yes.
But when it comes to claiming seniority in accordance with
Very
the
well.
service rule, so there is no cannot be, lots will examine the matter, my lord. There is no problem in that. But there cannot be any. And my lord, pursuant to the impugned judgment, revised seniority list has already been published.
Provision.
Yes.
So therefore, if your lordship wants to examine it, it's okay, my lord. But pursuant to the learned single judge's order, seniority list has been, my lord, revised and it has been published.
My lord,
Mr. Nair, there are two options.
Lordship.
Either we admit your appeals, dismiss the stay application, or we dismiss your appeal entirely.
Fine.
Which one?
Anyone which my lord chooses to, but
Which-
I'll make only 2 points, my lord.
Yes.
I have not concluded, by the way. My lord. There are other judgments are also there.
You already cite your judgments.
Yes, yes. My lord, in the more or less similar situation in two cases, my lord, Supreme Court has said one who has entered the service in accordance with rule, they will get seniority. That is, my lord, what will I do? My lord, 1987, Supply SCC 401.
Have you provided the list, sir?
My lord, can I make one submission? my lord?
Yes.
There is a provisional list on, they have prepared a provisional list. They have given a month's time to make the objections in pursuance of the directions of the honorable court. If my lord can have this on a date,
Sir, can you exercise your discretion of withdrawing the appeal rather than getting any observation which could foreclose your rights? Even apprehended rights, we can say. You have an apprehension that you may be considered. We don't have any apprehension in our mind that you are not entitled to be.
or to the seniority.
Yes.
My lord, I'll satisfy your lordship on that. I'll
You
satisfy your
have
lordship.
right to say something in rejoinder, let him complete.
My lord, can it
But then
capture
we will not
the
defer the matter, that is for sure.
lordship?
The matter will not be deferred. That is for sure. Yes, please.
Judgment to give. 87 Supply SCC 401.
You could have provided the list in advance, sir.
Sorry, my lord, he answered. It has been given, my lord. I'm told it has been given.
You will find it.
Supply SCC that I given it.
On the British list. Entering the the government took a decision.
My lord will kindly come to page 413, my lord.
Yes. Yes, please.
Line about 7 from bottom, my lord. The sentence starting with Rule 21. Rule 21 provides the governor on receipt of the list prepared by the commission under Rule 19 shall select candidate for appointment from among those who stand highest in order of merit in such list after taking into consideration the views of the High Court. The expression such list in Rule 21 obviously refers to the list prepared by the commission under Rule 19. It is therefore manifest that only those candidates can be appointed to service who are included in the list prepared by the commission under Rule 19. Perimeter rules here, my lord. Now, my lord will kindly come to paragraph 18, my lord. Para 19 at page 423.
Yes. Para 19.
Para 19 at page 423.
Yes.
The unplaced candidates were appointed to service in breach of the rules and they form a separate class.
You are
They-
reading at page number?
Page number 423, my lord, para 19.
Yes.
The unplaced candidates were appointed to this service in breach of the rules and they form a separate class. They cannot be equated with those who were appointed to the service from the list and second list of 1970 examination as their appointment was made on a recommendation of the Public Service Commission. They remain unchallenged. Similarly, candidates appointed to service on the basis of result of competitive examination of 72 before unplaced candidates were appointed form separate class as they were also appointed in accordance with rules. The unplaced candidates of 70 examination cannot claim seniority over them on the basis of Rule 92, Rule 22, as their appointment was not made on the basis of the list approved by the commission under Rule 19. In so-and-so versus so-and-so, this court held that an employee must belong to the same stream before he can claim seniority vis-a-vis others. Those appointed irregularly belonging to a different stream and they cannot claim seniority vis-a-vis those who have been regularly and properly appointed. Now, para 21, my lord. Now the question arises as to what seniorities should be assigned to the unplaced candidates. Their claim for assigning seniority on the basis of competitive examination of 70 is not sustainable in law as discussed above. They were appointed to service after 5 years of examination, and before their appointment, competitive examination of 72 had taken place, and the candidates selected under the examination had been appointed to service prior to their appointment. The direction issued by the High Court for rearranging the merit of 1970 examination seriously affected the seniority of those who were regularly selected in accordance with the norms prescribed by the Commission. Having regard to these facts and circumstances of the case, we are of the opinion that the view taken by the High Court on its administrative side and the state government that unplaced candidate of 70 examinations should be assigned seniority below the candidate of 70 examination is just and reasonable. In our opinion, it would be just and proper to assign seniority to the unplaced candidates of 70 examination at the bottom of the list of 1972. There were 7. So this is the view taken by law, because they have not borne into the cadre in accordance with rules. Eventually at para 28, my lord, at page 427. We do not find any merit in either of the two submissions. Rule 22 lays down criteria for determination of seniority of members of service. It directs that seniority shall be determined on the basis of the year of examination, which means that a person recruited to service in pursuance of a result of a particular year of examination would rank senior to the candidate who is recruited to service in pursuance of a result of subsequent year of examination, though he may have actually been appointed earlier in time. After the selection of candidates, several formalities are followed before appointment is made under Rule 21. These selected candidates are required to undergo medical, etc., etc. The lordship, I kindly skip that. But in view of Rule 22 of the latter shall be senior to the former, irrespective of the date of appointment. Since there was no challenge to Rule 22, an appointment is not shown to be illegal for reasons which we presently give, it must be applied in its plain term in determining the seniority of those recruited to service in accordance with rules. The petitioners were appointed in service on the basis of result of 73 examination, while respondents 3 to 15 were recruited to service on the basis of result of 72 examination. Therefore, according to Rule 22, respondent 3 to 15 are entitled to be senior to the petitioner. The mere fact that petitioners were appointed few months before respondent number 3 to 15 were appointed cannot override the express provisions of the rule. Now, if your lordship for a moment, my lord, comes to my lord page number 113, my lord, of the memo.
You've read the relevant parts from this judgment?
Yes, my lord. Then my lord will kindly come to page 118 of the memo of appeal. The seniority of a member of service, page 118, rule order 10, my lord. Yes, the seniority of a member of the service in the cadre shall be according to the order in which one's name appeared. My lord, the rule envisages only one method of selection. The APSC will selection, the person's name must appear in the selection. There is no dispute.
If we go by their case as observations in Mukul Saikia, the APSC included their names in the list in the year 2006. There is very clear finding in the Supreme Court.
Yes, 6. Even if that is to be accepted, my lord. So therefore, my humble submission is, my lord, the rule envisages only one mode of direct recruitment, that is selection by APSC. Rule does not approve of any regularization business, my lord. Way back in 79, my lord, Honorable Supreme Court said that recruitment is not a mode of, mode of recruitment. Then, my lord, one more decision, my lord. That Bhatnagar's case, 1991, 1 SCC 544. Here in this case, my lord, those who were regularized, they were directed to be placed below my 91, 1 SCC 544. এটা কিতাবটা ভুলিয়ে না পাইলো। Yes, my lord will kindly have para 7, 8 and 9 at page 548. The law is clear that seniority is an incidence of service, and where the service rule prescribe the method of its computation, it is squarely governed by such rule. In the absence of provision, ordinarily the length of service is to be taken into account. A dispute of this nature normally arises between, anyway, my lord, if there is a rule, then rule will govern, otherwise length of service, para 8. It was considerably disputed before us as to whether there were regular recruitment examination, and an attempt was even made to equate the examination contemplated under the rule with screening contemplated under the amended proviso. We have found no force in such a contention. The steps taken by the union government and the acceptance of such step by regularized officers clearly militate against such contention. The regularized officers admittedly remain outside the cadre until January 1977, from when their services were regularized. The union government was therefore right, while regularizing the services under notification, to direct that regularized officer would be placed below regular recruitments to the 1970 examination. So, my lord, the preponderance of judicial view seems to be, my lord, when it comes to seniority, it is essentially the service rule which will govern, my lord. Of course, if there is no rule, then length of service and not. Kindly see, my lord, here is a case in a particular recruitment process, hundreds participate, my lord, 70 come out successful, and they are appointed in accordance with rules. And my lord, the 30 manages to cling on to the jobs, my lord, and so Honorable Supreme Court makes an incidental observation that done nothing wrong in the Honorable Supreme Court observation at best can be said that as far as the process of effecting regularization is concerned, maybe Honorable Supreme Court's observation can be said to be to that effect, my lord. Nothing more, my lord. That observation cannot clothe them with seniority, my lord, which according to me, my lord, Rule 10 is the decisive. That's my humble subject.
Yes.
My lord, I'll just counter to what my senior has said. My lord will look into Rafiquddin, that judgment. No, I'll not trouble your lordship. My lord, when the initial appointment has been found to be not in accordance with the rules, the Supreme Court has said you are not entitled to
There
senior.
is no initial appointment of your clients, sir.
No, my lord.
They were just
I'm
backdoor
coming to,
entrants.
I'm coming to that.
Nothing beyond that.
I'm
Yes.
coming to that, my lord. But in Mukul Soikia, my lord, at least from 1611-2000, our appointments have been said to be born in the cadre, my lord.
Yes, going by the rule, you won't dispute the proposition that the seniority. is
My lord,
to be
I'm
known
coming
by
to
the
that.
rules. Yes
My
or
lord,
no?
that rule 10, my lord, order 10. I'm sorry, my lord, the honorable single judge has misdirected himself with regard to order 10. If my lord reads order 10 for a moment again, my lord,
Yes.
page 118. My lord, my lord, the honorable single judge has also said I'm a member of the service. Now, my lord will see. Seniority of a member of the service. Now, my lord, the member of the service has been defined in page 114, my lord.
Yes.
My lord, we'll only come to 114.
Sir, what is the process of selection?
My lord, it goes to the APSC. It's not been mentioned here, my lord. It's not been mentioned here.
But it goes through the APSC?
It goes to the
You
APSC.
never went through the APSC?
I failed
It's a
in the
fact.
APSC, my lord.
Failed.
I failed
And
in the
ultimately,
APSC.
APSC approved your regularization in reference to the order of the government in the year 2006.
My lord, that goes back to the date of the
You have
approval.
replaced that order of record, sir.
My lord, that order is there in the Supreme Court order. But
Does that order say, did you make any endeavor to contend that that order reads that our regularization will relate back to the date of 16/11/2000?
my lord, if I may just try to persuade your lordship,
Yes.
the lordship can come to
We
114.
can very well presume that the conscious attempt of the petitioners of the appellants in not bringing that order and record runs contrary to the claim of relief.
My lord, I'm sorry,
Yes.
this was never raised be herein before, my lord.
Need not be. That is the foundation of the entire litigation.
My lord, I'll
The
satisfy
date
your
of the
lordship on
date
that.
of the list.
I'll satisfy your,
You were having that finding in the single bench order. You could have placed that order on record here, sir.
my lord, the honorable single judge accepted that finding, my lord.
The learned single judge says list, select list as per rule 10. And that list in your case, your names were included by the APSC list in 2006. So if you had produced that list, the case would have been clear, whether
lord,
it refers back,
I'll-
relates back to the date of the government order or not.
My
That is
lord,
what the
may
question is.
just afford me an opportunity, 114, my lord, page 114.
Yes,
I'll try to interpret order 10, my lord.
please do that.
My lord would see what is written there. Member. My lord, G, member. 2G, my lord.
Yes,
Member means a member of the Assam Social Welfare Service. And service means the Assam Social Welfare Service. Now, a member would be when, my lord, he is appointed to the service. My lord, am I,
he is not appointed, he is appointed to the service, thus not pulled up into the service. There's a
right, my
little
lord.
bit of difference.
Right, my lord. There is a difference. I accept that also, my lord. So a member, his seniority now, my lord, is determined in 10. So you become a member, you became a member of the service, my lord. If at page 72, my lord, this is the select list and 75 is the appointment order, my lord. Type copy, one of the petitioners, my lord.
Yes.
My lord would have it, subject to medical fitness, so and so, so and so, so and so. He is hereby temporarily appointed on probation for 2 years. So and so plus other admissible advances taking over charge until further posted as so and so against vacancy. Now down below. This has approval of the state level empowered committee wide order dated 295 dated 3/2/2001. The state level empowered committee, which is required to give a sanction before any appointment is made it on 13/2, and he was born in the cadre on 21/3/2001. Now, how his seniority would be determined, my lord? The seniority of a member of the service in a cadre shall be according to the order in which one's name appeared in the selection list. If one joins the appointment within 15 days, so and so. My lord, this means, my lord, from a particular select list, when a person is appointed,
That you already argued, it is intercept between the.
Come,
those
because
persons
why
who
I'm
were
saying so,
selected
my
by the
lord?
Same selection process.
Why I'm saying so? This, my lord, contemplates two things, my lord. One, a promotion and as well as a direct recruitment. Now, my lord, there is no rule or order prescribed for giving seniority. So, my lord, the seniority would be from the date of continuation in service, as admitted by my friend also. So, if that is taken, my lord, my appointment is from, my lord, 16/11/2000. And Mukul Saikia, my lord, if my lord I can trouble your lordship once more with Mukul Saikia.
Yes, sure.
Para 45, my lord.
Yes. Yes.
Para 45. The decision of the cabinet and the notification issued by the state government pursuant thereto in our view are both in cognisance and in conformity with clause 11 of the service order to save the services of the private respondents from being thrown out of the job, which otherwise would cause extreme hardship and injury to them and to the members of their family. Now, my lord, proceeding further, page para 48, what the Honorable Supreme Court had to say in connection with Uma Devi, my lord. In the background of the aforestated facts and relevant provisions of the rules, we do not find any error or infirmity in the judgment of the so-and-so of the High Court which would warrant interference. None of the contentions raised by the appellants merits acceptance. The law laid down by the Constitution bench of this court in Uma Devi in the present sets of facts and circumstances will not be of any help and assistance to the appellants. So, my lord, the argument that was developed with regard to, my lord, that this regularization is in the teeth of Uma Devi not maintainable, that was also taken. Now, my lord, the honorable single judge in the judgment, my lord, has clearly categorically recorded a statement. In para 28, my lord, that I have become a member of the service. My lord, will have para 28 at page 215.
Yes.
Therefore, as the respondent 8 to 24 to have become a member of the service, so and so, with effect from 16/11/2000. So, my lord, if I'm a member of the service from 16/11/2000, my lord, my seniority will have to be counted from that day. By virtue of the decision rendered by the Supreme Court in so and so, which has attained finality and binding on the court. The decisions which have been rendered by, now relied upon by my senior, my lord, were held to be not applicable, and there is no appeal against this portion of the order, my lord. Now, one judgment which I would like to have placed before the Honorable Single Judge also, I'd like to place before my lord also, that a direct recruitee, from which date he can claim his seniority, my lord. I want, no, my lord, it's a decision which went from the Manipur High Court, 2025 SCC 689. It's a full bench judgment, pre-bench judgment, judge. My lord may have para 28.
Yes.
698. Before firstly proceeding to deal with the contentions of the appellant's counsel vis-a-vis that of the judgment in so and so, it is necessary to observe that the law is fairly well settled in a series of cases that a person is disentitled to claim seniority from a date he was not born in service. For example, in Jagdish Chandra Patnaik, the court considered the question whether the year in which the vacancy accrues can have any bearing for the purpose of determining the seniority, irrespective of the fact when the person is actually recruited. The court observed that there could be a time lag between the year when the vacancy accrues and the year when the final recruitment is made. Referring to the word recruited occurring so and so, the person said cannot be said to have been recruited to the service only on the basis of initiation of process of recruitment, but he is born in the post only when formal appointment order is issued. Then, my lord, that was further carried account. 29. The above ratio in so and so is followed by this court in several subsequent cases. It would therefore be appropriate to make specific reference, considering the seniority dispute in reference to so and so. Having regard to similar provisions, the court approved the view that seniority is not to be reckoned from the date the vacancy arose, but from the date on which appointment is made to the post. The court particularly held that retrospective seniority should not be granted from a day when an employee is not even born in the cadre, so as to adversely affect those who were validly appointed in the meantime. My lord, the other paragraphs also deal with the whole thing, and then, my lord, the judgment in para 39 also. Same things, my lord.
Yes.
The judgment in NR Parmar relating to central government employees cannot, in our opinion, automatically apply so and so. We also feel that NR Parmar had incorrectly distinguished the long-standing seniority determination principle propounded in inter alia so and so. There is 3 judgments and several others like in education law for determination of seniority makes it abundantly clear that when service jurisprudence, under service jurisprudence, seniority cannot be claimed from a date when an incumbent is yet to be born in the cadre.
Yes.
So, my lord, my humble submission is that by that appointment regularization having been approved by the Honorable Apex Court and the Honorable Single Judge having accepted that, my lord, person born after that and not in the same year, the next year, my lord, we do, and my lord, further in the service orders, there being no provision for determining the interstate seniority, the seniority would be, my lord, the date of appointment. And I'm not claiming, my lord, any seniority prior to 16/11/2000. This is my humble submission, my lord.
Well, only one thing, my lord. Sorry, my lord.
Sir, rejoinder.
No, sorry, rejoinder. My lord, rule 5C, my lord, at page 116.
Yes. 116.
Yes. In the cadre of district social welfare, sorry, madam, 116.
Yes,
In the cadre of district social welfare officers, CDPO, superintendent, home, principal, so and so, provision, etc., etc. The cadre shall be filled up by direct recruitment through commission as per the norms fixed by the Ministry of Welfare, Government of India, by the Social Welfare Department. So this is the mode of recruitment.
I'm sorry, my lord, that is not correct. My lord will also read along with that page 120. Half should not be shown, my lord. Full should not be shown. Page 120, my lord. That is the schedule and that is the decision. Class 2, 40% by promotion, page 120, my lord. 40% by promotion from amongst persons
So how does
who
it
have
conflict?
rendered 10 years of.
How does it conflict, my lord?
Because, my lord, by this regularization.
but it's
is-
not a promotion, sir.
No, my lord, that has been against the promotional quota, my lord. My lord, we only have that page 22, it's against the promotional quota, my lord.
Yes, that we have seen.
And secondly, my lord, the judgment which my learned friend has realized just now, it was a case of direct recruit and promoting mind. Here we are concerned with two stream of direct recruitment. End of the day, my lord, there's something called equity also, my lord.
My lord, para 20, my lord said that 2006 APSC list was regularized. My lord, I'm sorry, my lord, if my lord reads para 22, my lord need not go back to that.
Yes.
It only says APSC had conveyed its approval to the regularization of the respondent services. Because that
What
was
date?
one,
On what date?
my lord, no, the date, my lord, is, it has been
24/2006.
6, my lord, that will go back, my lord. Unfortunately, that will go back.
Sorry, sir.
My lord, there was no date
raise
given.
No such presumption. Unless the order is placed on record, we will not raise
Fine,
any such
fine,
presumption.
fine, my lord, fine, fine, my lord.
No, no.
Much obliged.
All right. Arguments heard, judgment reserved.
Much obliged.
Deep privilege.
Government may have taken action to regulate. Yes, you should.
Yes.
Let me. This relates to blacklisting of the petitioner. My lord, by origin to the e-tender, they have introduced this, my lord, your losses may just turn to page 103. District origin, my lord. 5.1.18.2. It says, my lord, if the sample of the drug drawn from any supplier of drug fails quality test, or the sample does not conform to statutory standard, specification, then the supplier will be liable for penalty based on the nature of the degree of default as given below. Nature of the default has been given and the penalty is prescribed. Your losses may turn to next page, my lord. Item 2. In case of 3 batches of a particular drug item supplied by the firm failed the quality test, product department, in addition to the above penalties, firm shall be debarred from participation in any tender.
Please do notice, sir. Please do notice, call them to file a reply or counter.
My lord, virtually no so cause has been given, my lord.
Without reply, can we proceed, sir?
My lord.
Issue notice to the respondents.
Because I was only for the 4 tenders were there, 5, 6 and 9. My lord, in the other states, my lord.
We'll have to decide the appeal, sir, then.
My lord.
Shri, Mr. So-and-so appears.
My lord.
For all the respondents.
My lord, yes.
If praise for it is granted. 2 weeks time to complete his instructions. List on 21st March. 22nd March.
Published. But
One percent.
In this appeal, a notice was issued. The direction to deposit 1 lakh rupees as a part of alimony by the appellant. Appellant has deposited, my lord, on installment, and on, my lord, last balance amount was deposited on 23rd February 2023 as per the order of 25-1.
Yes.
So, my lord, 1 lakh has been completed as a precondition. So my prayer is that, my lord, appeal may be admitted and placed for hearing. my lord.
Where is the counsel for the respondent?
Respondent is appeared, my lord, this is the copy, my lord.
It was earlier dismissed.
SK Agarwal, my lord. This is the copies for online payment for last. installment.
There is no notice on restoration. Whether there was any notice.
So it's service, fresh notice. Fresh notice. 21.
This is a copy of last installment of payment, my lord. Online payment. It was directed to make payment on account.
21, 10, 20. Yeah.
10/20 का order नहीं पाई. 30th March. That's why I was confused. Pagination of what? 28. Correct order form.
Good. I just. I give it.
There.
Number
Pagination.
29.
29. Target picture. 12. 29 is 25 or 30. This is missing. Now, whether service is complete.
Yes, my lord. They have already appeared and service completed.
Learned counsels admits. All for the records of. Records receipts, okay, admit. This for hearing. The month of.
June.
June.
Bless.
May please lordship, whether this case is pertains to issuance of staff vendors license to the persons by the deputy
You are
commissioner.
not ready to face competition.
No, not that, but whether your lordship please to see the page 84.
Let everyone have the opportunity to earn his livelihood.
No, the ground on the ground given in the order and the ground by which my lord the learned single judge has rejected my petition are totally different. At page 84, your lordship please to see. The ground is needy and genuine persons. Last but one paragraph at page 84. While hearing the concern expressed by the members of the petitioner's association, it is noted that some very needy and genuine persons who are unemployed and unable to find out any source of livelihood have been granted vendor's license. As such, the grievance of the members of the Writ Petitioner Society are found to be not plausible. But your lordship please to see the ground given in the rejection order of the learned single judge at page 152 at paragraph 16. In view of the exposition of law, the state cannot be considered to be a legal injury. But two grounds. On the ground of I don't have the locus standi, and second ground is that it was in the public interest.
Can
My
you
humble-
file a writ against the bar council not to register new lawyers?
I mean, essentially, it is the same ground.
But if your lordship is to see on what ground it is based upon.
Learned single judge has elaborated on the point of view of whether
Require
it is
necessity.
necessity.
But page 67, your lordship is shooting. 67, no? Good one. Page 67, 68, basically. On what ground it can be given? Paragraph 20, last line. Last word, at district and subdivision headquarters and in huge towns, where vendors are readily found, the number of them shall be such as to offer reasonable facilities to the public, but it shall be limited so as to allow a moderate income from the sale of stamps being derived by it.
No,
That was not
is it your ground that the reasons on which the license has been granted is not germane to public interest? Is it for mala fide intention? Is it?
No, I don't ground, bona fide ground is not there. But can it be by public interest in the sense that we have the 39 members and 26 members have been newly given license?
All right. Anything else?
This is the submission.
We have
The
noted.
ground given in the affidavit in opposition and the
The ground
ground
for grant of license is different.
differ. Okay.
Okay, heard, reserved.
This is called the Tanya Malik. Minimum marks in equity. 5 hours.
Sir.
Now there is nothing left. Tanya Malik and one more judgment recently. Suitability of the candidate has to be judged is the exclusive domain of the interviewing authority.
That is true, my lord, but Supreme Court has also said that it has to be in the rules, my lord. Here in that case, rules are silent regarding that.
So rules are silent. Ultimately, the recruiting authority judges the suitability. That is what the rules prescribe.
My lord, what had happened in this case? The rules say, my lord, that the cumulative mark of written and interview will be taken note of. But in the advertisement, my lord, it was said that in the as far as the Vivavacy component is concerned, in that segment, 60% has to be secure. Otherwise, my lord,
Before participating in the process, you have to challenge that.
no, my lord, that
condition.
aspect, no, that aspect has been taken note of by the Honorable Supreme Court in Ravinder Singh's case, my lord. We have brought on record those judgments of Table Court. Within compilation.
So this is ultimately the satisfaction. To rest assured that we have been a part of the interview committees and we find candidates who have performed exceedingly well on the written side, written examination. They don't utter a word in interview. What to do?
In an appropriate case could be, my lord, that is right. If a lordship will kindly have that judgment, my lord, that regarding that participation part, if your lordship will kindly come to page 66 of the compilation, let me first steer clear of that controversy, my lord.
66.
Yes, it starts at page 66. My lord will kindly come to paragraph 2 and 3 for the facts. At page 68. The citation to 2010, 3 SCC 104. The facts and circumstances giving rise to petitions are that in order to fill up.
We'll hear it some other day.
Well,
Otherwise also.
it will take some time, my lord.
It will take some time. Because we don't have the same bench after 2.
I know, my.
Oh.
Right. I think that we can give on the next day, my lord, or that's a compilation, or it should be retained. my lord.
You give on the
got
next
it.
day. You retain it with yourself. Yes, jointly prayed, list on.
My lord, let it be after the third week, my lord.
9th May.
You can furnish a list of the citations, just hand it over to the court martial, not the judgments,
My
only the
lord,
list.
we'll do that, list of books. We'll do that. Episode কিবা এটা আছে নহয়?
Order.
This is also a longest matter, my lord, where I,
So we can have it in the third week of May.
my lord.
Yes, prayed list in the third week of May. For hearing.
My lord, in fact, 33, 36, 38, these are all my matters. 33, 36, 38, lots of may give on different dates, my lord.
If you please ask the court martial.
My lord.
Assign you the appropriate dates in
Yes.
the month of May.
My lord. In the 33, 36, 38, huh? Deeply obliged.
I'm in 38 minutes. I'm 38.
Lordship, may the matter be passed over for the time being. Mr.
Yes,
Arthur,
prayed list up to 2 weeks. Yes, prayed list up to 2 weeks.
May it please, Lordship, this matter has got infracted.
As stated by counsel for the appellant, comma, the instant writ appeal is disposed of as having rendered infructuous by subsequent events. Pending applications, if any, are also disposed of.
How like?
Mark attendance of all present. 38, there is an adjournment slip. 4 weeks. None present for the parties list of 4 weeks.
Lordship, time.
Yes, prayed list of 4 weeks. Prayer, you please mark her, record her prayer. For Mr. K.
32. None appears for the appellant. List after 2 weeks. Mr. R. Mazumdar appears for the respondent.
Obliged.
My lord,
It is that Supreme Court remand in a pension matter. So if not possible today, on 9th, I am praying as the first item in the hearing column because Lordship may kindly have a look. I have no option left. My petitioner is about 70 years old.
Areas.
He is a retired sub-registrar. At best, I'll pray on 9th as first item in the hearing.
Prayed by counsel for the appellant, list on.
9th,
Let us have it on a hearing date then.
10th, 10th is not a hearing day, 9th is a hearing day, March.
Or we can have it on.
Lordship.
16. 14 or 16. You do that.
9th.
9th.
9th as first item in the hearing column.
No, it'll be there. Why are you worried about first, second, right?
Lordship. May I accommodate?
You make a prayer if required.
Lordship,
On 9th, on 9th.
on 9th, yes. Deeply obliged, Lordship.
So that has already been adjourned. no?
It is already adjourned.
You give the dates.
Please, my lords.
Yes.
My lords, this PIL was filed in 2019 in the backdrop of the protests which had happened in Guwahati against the passing of the Citizenship Amendment Act of 2019. Now, when these protests had happened in December 2019, Milods, there was something called, which is commonly referred to in India as internet shutdowns, which was imposed in the state. Milods will be well aware about internet shutdowns. Rajasthan, Milods, in fact, is one of the states where internet shutdowns happens the most.
Only during examinations.
Yes, indeed, Milods.
You are against that only.
Milods, we have challenged the constitutional validity of the rules of 2017, the temporary suspension of telecom services, public emergency or public
Honorable
safety.
Supreme Court is already seized of the Rajasthan issue.
Milods, it is a little different, Milods. The validity, we are challenging of the entirety of the rules, Milods, not of certain
Let
provisions.
Honorable Supreme Court take a call, and let the matter be decided, then we'll see if anything else is to be done.
Very well, Milods. That is, we are amenable to that.
Yes.
In the interregnum, Milods, for now, there's one small prayer, Milods, which I have a humble request before your lordships. Milods, when these matters were initially filed, there were 4 PILs, Milods.
Mhm.
The state of Assam had filed its counter only in one of the PILs, Milods. And that PIL is Banashri Gogoi PIL 78 of 2019.
You want that to be tagged? with
Yes,
this?
Milods, it has been disposed of, but the counter affidavits
tag
are
the
germane,
record.
Milods.
We'll
Yes.
tag the record.
Yes, yes.
As prayed by the council, Mr.
Angaj Gautam, Milods, A Gautam.
A. Gautam, registry is directed to tag the record of PIL number so and so within bracket disposed of with this PIL, with this
78.
addition PIL, and re-notify the matter after 4 weeks.
Obliged, Milods.
Your lordship may fix some other day, my seniors on left.
Any objection on the other side?
I am for, number 7.
I'm 8, my lord. I'm
As
appealing on.
prayed by counsel for the appellant, list for hearing in the month of May.
Highly obliged.
So we have not interfered with the order of the learned single judge, but your arguments on Rajiv Kumar's case has been dealt with. We have held that after the charge sheet memorandum of charge was submitted, you will have the liberty to suspend him once again under 6(1). That exercise you can do it even now, any day you want. So that's the liberty. If you want, you can place him under suspension once again under 6(1). The earlier was under 6(2), now it can be under 6(1). Rest of the things, no disagreement.
Item number 1 for orders.
Today.
21st February.
21st February. Yes. What about this central share? Is the central government there with before us? Why can't we persuade you to file the affidavit? And the Advocate General says that the central government has assured. So let us have this assurance on record in form of an affidavit.
Uh, In terms of our order dated 21/2023, the matter was examined by the competent authorities, whereafter the respondent number 4 has filed an affidavit dated 21/2/2023, indicating that the necessary funds for completion of the project can be made available. Full stop. Today, when the matter was called up, Mr. D. Saika, Learned Advocate General Assam, has further submitted that even the central government has promised to provide its share of the funds so as to complete the project. Full stop. Ms. A. Gayan, Learned CGC, appearing for the respondent number 1, prays for and is granted 2 weeks' time to file an affidavit on behalf of the Union of India, complementing the stand of the state respondents. Full stop. Let this matter be listed after the affidavit is brought in record.
Let's fix the dates. It's on, can I do 16th February? Yeah, 16th March.
16th March.
16th March.
All right.
We'll take it up. Call it out in routine.
Item number 2.
Yes, 72. Okay. Mhm. Mhm.
Is it saying like not able to type out? क्या कह रहा है समझ में नहीं आया
One three. Yes, please.
They omitted 379 in their affidavit. The direction was regarding 370 and 379. So in their affidavit, they have conveniently omitted to mention about 379. Whether that stays in 379 below.
Is that stay which you are referring to is in relation to 379? Because your affidavit and documents are silent regarding 379, which is contained in the order. In view of the above, the PIL is disposed of with a direction to the respondents will take steps as indicated in para 3 of the affidavit opposition. So para 3 Mhm. Mhm. Mhm.
wanted enforcement part. No, those people have, if they've got a file application. that is it.
But he is not, he is not regarded to the affidavit.
This affidavit is uncontroverted, sir. If their affidavit is not controverted by you, what to do? Why? You are not controverting the governments in their affidavit. They have already allotted the land of admeasuring 5 bighas for the park. That is not controverted. What more is wanted? When?
That is before.
That is prior to their affidavit. So after that, they have filed the affidavit saying that the land for the plot has been allotted. What? How can you anticipate that they will not work? Immaterial, but they have been asked to create a park. They will have to do it.
Preliminary work is started. That's what they know. Preliminary work.
They in the order of GMD, they have indicated that preliminary work has started. Then you counter that affidavit. You file a counter to that affidavit then. No, gentlemen, if the intention of the court was that the land should be saved by creating a children park, then it has to be executed in its entirety. You just can't shun the burden saying GMD will take care of the things. No. So, it's all right, but the court will ensure that the park is
In place.
Absolutely in place as per the intention of the court. So you file the additional affidavit or counter affidavit. And counsel for the respond number 2 has since superannuated counsel for the appellant petitioner to take steps for bringing on record the incumbent presently holding the post. He may also file affidavit, counter affidavit in regards to the averments made in the affidavit filed on behalf of the respondents. Respond number 1, respond number 3, list after 4 weeks. She is talking about respond number 2.
Yes.
Okay, you take steps, list up 4 weeks.
Pattern numbers 3 and 4.
You file the affidavit, sir, we'll find out whether it has been complied or not.
Which area may mention excavation? Is it permitted?
No, I don't. But in low grade, I can't.
No. You in Gondapuram, any mining activity inside the forest. Oh, that- that-
Why? They permitted. in low
Like,
grade?
that's-
You are on notice. Have you filed the reply? Okay. So we are not bothered about that. We are bothered about the activity which is being taken place inside the forest area. Mhm. Mhm. Right. Okay. Mhm. But the question is, what they have alleged is that this activity of stone crushing is being allowed inside the forest division. Read the synopsis 4/10/21, the order. Mhm. Not inside the forest. Okay. But then why the CCF is required to issue the order? Chief Conservator of Forest. Who is the CCF? He doesn't have jurisdiction to pass this order. Let it be. Second PIL. This order is this is there in the first PIL also. Page 73. What is the prayer? Page 25. Okay. We are on PIL number 79 or 76. Mhm. Mhm. Yes. Mhm. Okay, so this order came to pass during pendency of 76. The stay is already there, so we'll make the interim order absolute or other specifics. Yes. And what about the first PIL? Will become that will also be allowed. Okay. Is it?
This is happening. Rest people come and support the patient.
Okay, very well, we'll pass the orders. Disposable repairs.
Item number 5.
We got the entire forest created, reserve forest created in this.
Just a minute. Very difficult terrain. But is it something?
Reserve. Then we will become the king of the. That's right. It's just like. Getting in the alignment of action, which is important. Not directly.
Yeah, we do what's. क्या डायरेक्शन है?
Page 180 report.
वो तो है, correct.
लोग मरेंगे. It is passing. And this happens. What will happen?
Can anyone explain page 180? Have you seen the picture? So how can the railways be so callous? Then oh, these photographs. These are pictures pertaining to 2022.
Yes. This was a message.
Yes. But then can you be so sure that the same thing, same events will not reoccur? Yes. But whether you can have any measure to foresee that this kind of rainfall will not occur again and cause a similar kind of damage.
आजकल जैसलमेर में होने लगे. Even in Jaisalmer, the entire sand gets washed off.
Nature's feeling.
Just really more than that. कर दीजिए.
What direction do you want us to give? Remove the railway line. Then. So that they have already given the affidavit. We'll keep this petition pending. If anything new happens, you file the affidavit. We'll see if any fresh direction is to be issued.
pleadings have been exchanged, admit this client, this for hearing in usual court.
Item number 6.
They would have the safety measures in place at the petrol pump. Let us see if the board has considered that. They must be having that no objection. Do we have the stand of the Central Pollution Control Board? Mhm. 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 That can't be gone into a PIL. Have you realized that the petrol pump has been commissioned without due permissions? Is there an allegation? Then those are disputed questions of facts, sir, then. Hmm. The corporation definitely carries out the spot verification.
Yeah, yeah. It's okay.
BPCL represented by, to file your affidavit. Yes. From the dispensing unit. $50 meters is to be from the dispensing unit. 140 and 141. Well, sir, what to do? These inspection reports are there. Are we now supposed to go on for spot verification in the AL proceedings here? Not the scope. There's no need. He has pointed it out. The distance is required to be from the dispensing unit. All right, you file your affidavit.
That's for number 4. Which has bought a 4 weeks. 4 weeks.
4 weeks.
4 weeks affidavit.
Item number 7.
For weeks time.
4 weeks time to file is under respect for my petition. Yes.
Item number 8 for hearing.
ये वाला अच्छा है सर, इसको टेकअप करिए। इसमें तुमने एजी से बोला जॉइन इन।
Luckily, I had the occasion to see the bill while going to the airport. So your concern seems to be genuine. Yes. You feel that even the government would be keen enough to protect this is something. There is one more bill which the government is developing by way of that tourism.
Silsako.
इसमें यस यस हाँ हाँ तो नहीं होगा तो करेंगे ना
लगता है वो फिशिंग राइट
हाँ ये वो फिशिंग राइट यस
Right.
हाँ अब रिकल किया मैंने तो थोड़ा वापस सुनना पड़ेगा नहीं है
Can you recapitulate the arguments, please? Once. Yes. Any private interest therein? Having license of fishing leases. Traditional right of encroachment. Society, that's right. Mhm. Yes. Definitely. Yes, yes. We have to preserve, this has to be preserved as a matter of fact, yes. Yes, it does. No dispute about that.
As a matter of fact, no.
Yes.
Mr. Majumdar, this, the mechanism under section 21, this is akin to the mechanism in a land acquisition act. Supposing somebody's established right has been taken away due to a notification of a wildlife, then the question of compensation may arise. But you are saying that not this random people who might have some and which is not even
Commercial
established,
interest.
commercial interest. Mr. Naik.
Now people started coming and staying. And they were exercising their right in that way. Now one of the people with the woman declared that a victory and my lord, they created a society form, which my lord will implement the society. It is in that manner that it's by converting our traditional rights into a more scientific. Our rights were there from before, so the even my lord, the
Bill came into existence.
after the bill. After the, even before the bill was declared. Now what had happened? 89 there, and my lord, the protection requirement, that it's a land. So the definition says land. Definition, my lord, what is exactly meant by land? My lord can have the violent.
Yes.
270. That includes now take another water sample. Take the artificial or natural. Artificial wetland.
Yes.
That includes canal, fix and other water sample. That will take the artificial or natural wetland. And also include that. So wetland is also a wetland. Now, my lord, how to write it? Come on, I don't know write it. I think. When a notification has been under section 18, the controller shall acquire in the existence, feature, and extent of the rights of the keeper. If or over the land complies with the limit. So, my lord, pausing here for a second. He must do that exercise independently, even if there is no objection. Now, my lord would see, 51.
Yes.
When a notification has been under section 8, the collector shall, within a period of 60 days, publish the regional language, allotted mark this, in every town and village in the neighborhood of the area comprised there. A proclamation. My lord, a proclamation here in this of in the area, wherein, my lord, the sanctuary, the area would be the big area, the vast area. They had never issued. But in the first term, people came to, they submitted their, and accordingly, the deputy there, my lord would have that order, collector's order, and page 90.
Yes.
I don't think on to page 90.
Some Wetland Preservation Act or something like that.
But the SC and ST of 94 plus 1. That the SC and ST could have been earning the by capacity of the department. Even now, of 100 ST, 100 ST. Back in 1976, government found a cooperative society. And since then have been continually the AFA started granting this purchase in 1984. In 1992, the deed was accorded to it. Even then, it was from the deed and it. After discussing everything, the collector was in the light of the above. In the light of the above, section second paragraph, 95. In the light of the above, first actually keep the opportunity like you for the elected. The later would suffer particular. Therefore, my considered view is that there should not be because we an alternative piece of for this that we call. We are not against the declaration of that. We are saying that if you are doing that, also one of protect for our life. It's the collector. This order was affirmed by the government. At this. After discussing all the aspects of the last. I'm not going to see what it is. Government, government deliberated at great length. They go into providing a congenial environment to without adversely affecting the interest of the British aim was protect. If the love and care of the children of the earth is not put to under as a presumption, of the shall be brought back to the original as obtained before the close of the town. The order was has been passed with the hope that the people will continue to flourish as an ideal habitat for a breeding ground for fish and a source of relief under all the benign care of a well-intended and the official interest. Now, my lord, what they have done. This order was passed in 2002. Then, my lord, in the year 2000, August, simple order was passed that we are withdrawing this order and the order under section 18. Fine. Thereafter, my lord, there is procedure. Once the procedure, my lord, the proclamation has defined under section 21 was never. That was the categorical case to be honorable secret. The proclamation was not issued, and my lord would see the manner in which the orders were. That my lord would find the additional evidence. At page 209.
Yes.
Government in the Department of Environment. Appointed the for inquiry. These are an extent of existing in favor of each person comprising master product. In the revenue within covering an area of land for the purpose of already 3% of 12.9. 3% the above proclamation under section of the violent.
Yes.
The execution of the proposal is office for the next step. The same way published. The petition has subsequently also published in the these are filing of already left. No sort of official publicity.
Yes.
कुछ नहीं पर कुछ नहीं 20 भी नहीं है 14 पर सबमिट करो ले दिया
Yes.
No sort of objection on any of our people. In view of the above, I do therefore not support. Hopefully, we will. Why they are not? The area land is not. When the collector was passing this, he had the objections and the order of the collector earlier passed. Even that were not taken into. It is under the mandate. If the notification is not published, one is gazette, paper third is notice. If all the three are not followed, other than that whole.
There is a big difference, sir. Land acquisition means the person who is being deprived from his property. Herein, there is no right as such to the property. You may be having some claim of earning livelihood from the wetland, but as such, there is no right for the property. Yes. No, we have read the section 90.
Section 90.
We'll deal with 19, so don't worry. We've read it. Yes.
Controller shall inquire. Determine the existence, nature and extent of. Now, my lord, forgetting 21, not even going to 21. Even if by 19, that order that has been found, there is no reference.
That is right over there.
Yes.
And my lord, the judgment of the honorable filter, my lord, there was.
Yes. Yes. Yes.
It is 2-7.
Yes,
The
yes.
most significant aspect is that is the earlier recommendation of collector made on and to the consequential decision of the government to take the under the scheme order dated 29/5 is also unnecessary. Yet these 12 reasons review the second process without indicating any ground for the change of plan. More importantly, the collector stated that no objection of change to receipt. There was no reference to the pending claim of and the already made declaration in the favor noted earlier by the same officer, that is the collector on second one. Then he proceeds further. The decision taken by the collector and the government, the earlier one, and in the context of 1955, and those decisions, it is were supported by very hard. The collector and the department on their opinion and voiced their concerns with reference to such well-considered decisions cannot be reviewed without a similar by application of mind to all relevant parameters. Moreover, it is illogical for the collector to say that none had put forward any claim in pursuance to the since the inquiry by the collector also required him to determine the existence of rights as for the government record. While the collector and principal secretary in the earlier law had already right to develop here absence of record does not permit the collector to develop without discussing why the opposite is taken by him of the second. Then, because earlier opinion by the collector, Manor will have Kawasaki. The proclamation under Section 21 is required to be published to the line and more particularly in the neighborhood of the state. But here, non-compliance of the requirement of Section 21 is seen, and in my perception, the publication of the proclamation is not an acceptable substitute for the statutory process of publication. The adherence to the prescribed mode of publicity of the government confers a valuable right to the and the exact chosen method of publication cannot be acceptable substitute for it, particularly by the statute. There are decisions which support or without it to grant understanding. Moreover, it is settled law that since law that if a particular method is prescribed to exercise power, any other method of the fishing right paid by the is not related to these by the on conflict. Those exercising additional are entitled to secure these of government. Such constitution finds support from the government the fishing right for the each protected before the as vital if the government wants to change the and without affecting such the country cannot be then Malad 19 says I agree rights cannot be unavailable. Subsequently, Malad finally the honorable court gave the liberty to the authorities to Malad proceed with the matter and undertake the exercise under the act in the manner. Now, Malad, I understand this honorable court will also not like a person to be Malad there. I also belong to court. Being a resident here, he also be. Malad, there has to be a debate
Midway is already there, sir. They have only used 4.1 square kilometers out of the entire area of.
Beyond that 4.1 kilometers, there is nothing. The whole area has been not encumbered into 4.1 kilometers, there is a railway line. That also gone. Now the whole area 4.1 is there. So that is the only sanctuary there. My fear now is as a the protection that is being given is to secure the unauthorized occupation in the other area. So my lord is saying, my lord will take into that aspect also into consideration. If the whole area is not restored back as a wetland, my friends said 20 square. If 20 square kilometers is not protect, then only prayer before my lord that the government, in terms of the earlier decision and the others, they must also apply their mind our way. This process cannot be communicated. I don't want this, but at the same time, they cannot be obligated to our. Because we know that provision will be done. From generation, they have been doing that. That has to be taken care of. If Manoj is permitting one to Manoj,
How do you say that only 4.1 square kilometers now survives out of the 20 kilometers which is there in the records?
unfortunate. Thanks. After the.
What is the declared wetland area? There must be some declaration.
Yeah, only 4.1.
No, this is a protected area which you are saying, but the entire area of the deal, as per the revenue record, what is that? Where do we get that from? 10, not 20. You said orally, you said 20. No, that is okay. But what is there in the record? So this query is coming for future actions. Encroachments apart, what actually is the measurement of the deal in the records? That is what we want to know.
Disputed question that claimed that we adjudicated.
Should be asked them regarding the exact area of the. Well spoken.
Okay, very well. Anything else to say? That will come in due course of time.
Has seen from common records that this was a competence by the government for us. It's not that from that day.
We will take into account everything what was.
So in the sidelines of this contest, I'm finding it, Mr. Nair, you get good fishes anymore in Dipperville?
The rope which was there, which was there, it was so tasty. Now, my lord, you can't see the all garbage is from there. Earlier, my lord, used to be actually small vanish. And it finished the inside, which is starting the first
Arguments have been concluded, judgment is reserved.
Item number 9.
वो तो दिया ना जगदीश प्रसाद मीणा देना that others have just followed that main judgment. Jagdish Prasad. The judgment provides that all the concerned persons who are likely to be affected would be heard. That is what the judgment says. So why do you apprehend that you will be heard, condemned unheard? This covers Kabristan. Extensive action. Can they give tenancy on government land? On government land? Read the provision, sir. Read the provision that the Kabristan, the committee is empowered to give tenancy on government land. Please, read. To rent out government land, whether that is a business of the. Litigation. If there's a tendency also, they cut out. It's very limited to importance. No one else. We can pass that order. So we'll pass that order and direct that all concerned persons who claim to be having a right will be heard. A reasoned order will be passed. Obviously, you have the right to challenge it. We'll pass the appropriate order. Dispose of.
Item number 10.
An adjournment slip has been circulated by counsel for the petitioner. You have circulated. Okay, list of 4 weeks.
Item number 11.
Mhm. Counsel for the petitioner pays for and is granted 4 weeks time to file affidavit on behalf of the petitioner. List of 4 weeks. Done. ये भेज दीजिए अभी लिखा देते हैं।
আজি বহুত চিএবি হ'ল দেই। তিনিটা হ'ল না।
এইটো
নেকি এইটো কিছে নেকি আচ্ছা